it up. So if you're doing maintainability, then just narrate your points on that, please.
Your Lordship, because this point actually goes to maintainability also, because what they have done is they have amended the constitution in the garb of a legislation. So it also goes, so it's dual purpose. So because they have not followed the constitutional provision of amending the constitution if they wanted to do so, therefore on that basis it is maintainable. And then on, as I said in earlier beginning of my argument, on the contents. So the contents also, so in essence, before I go to the main content, 1843, if true purport of 1843 may kindly be seen, because there were some questions that what fundamental right has been violated and what has been done, whereas 1843 is silent on that. It does not requires that any fundamental right has to be violated, then a petitioner can come to this honorable court. If I may be allowed to read, and I'll say what actually it entails. So, without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers, so that is first consideration, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights is involved. So, only if there is a question of fundamental rights is involved, and here it is a question of fundamental right which has been involved and a question of public importance. So only if a question arises, whether or not any right has been violated or not, or breached or not, in my humble submission,
Precisely which fundamental right is the petitioner seeking to enforce?
that's a question. If a question relating to fund, so one of the rights is access to justice, for
No,
example.
it is with reference to the fundamental right, है ना? आप जो read कर रहे हैं वो public importance कर रहे हैं. With reference to the fundamental
So,
right,
Lordship, in fact, if I may,
conferred by Chapter 1 of Part 2 is involved.
if I may put
You
it this
cannot
way,
read in bits and pieces.
no, if I may put it this way, the rule of access to justice is actually a thread that run across all the fundamental rights.
What if the law provides access to justice?
The law access to justice is Article 4 and 8, and in fact there are judgments of this honorable court, as your lordship, Mr. Chief Justice was saying in the first hearing. In fact, there are multiple judgments of this honorable court, but the only judgments which perhaps are binding of this honorable court are those of 15 or larger benches. So of course it is open for your lordship to revisit those cases. If your lordship,
Counsel, how is the petitioner's access to justice impaired by this law?
lordship, the reason that if I talk about lawyers, the petitioner is also a lawyer. Petitioner is also a lawyer.
Maybe a lawyer, access to justice जो है, how is that being affected?
Because if I have a petition and that I want to bring under Article 184, I am prevented by this committee, because it will first go to the committee. They may or may not decide that this petition should be put before the Honorable Supreme Court. What I am submitting is, if I may be allowed to complete my argument.
If the Chief Justice has exclusive rights, then access to justice is not affected.
No, the Chief Justice is not, there is no provision prior to this law that the Honorable Chief Justice will examine the petition. It is his prerogative whether he fixes it for hearing or not, but he will not decide whether this petition should go for hearing or not. Whereas this committee is going to decide, and it is not clear from this law whether there will be a right of hearing or not.
I just want a clarification. Is your interpretation of Section 3 of the Act that it's a determination by the three-member committee which matter can be heard or not, or is it merely determining who will hear the matter? Not if, language or if it will be heard.
मेरी petition का मालूम
ये petition छोड़िए, कानून पढ़िए ना
जी, मैं कानून ही पढ़ रहा हूँ, पेज 9 पे है
ये जरा वजाहत कर दें दोनों बातों
पेज
में
9 पे है
Mr. Hassan,
जी सर
I think you are going ahead of the argument. You're going into the nitty-gritty of Section 3 and 4 and 5 and 7. The first question that needs to be answered is, जो आप आर्गुमेंट कर रहे हैं कि जी एक्सेस टू जस्टिस और कौन सा फंडामेंटल राइट अफेक्ट होता है. Now, access to justice is itself a fundamental right.
Absolutely.
Or what is access to justice? Access to justice is to be able to approach a Supreme Court or a court which is independent. So where any law or any provision of any law, according to you, affects the independence of judiciary, then it directly affects your fundamental right to access to justice, because part of the access to justice is access to an independent court. Number one. आप हमें ये आर्गुमेंट बताइए कि ये जो एक्सेस टू जस्टिस का फंडामेंटल राइट है, नंबर वन, ये किस तरह अफेक्ट होता है. नंबर टू, अगर ये फंडामेंटल राइट अफेक्ट होता है तो दैट बाय इटसेल्फ बाय डेफिनेशन is a question of public importance. Number two. I think we have gone beyond that. The very fact that one side is saying it does not affect independence of judiciary, the other side is saying it does affect the independence of judiciary, and this court is called upon to examine whether it does or it does not. So the very fact that we are examining that question itself shows that it is a question that needs to be examined, and is therefore a maintainable issue or a petition.
In fact, related to that also is a question. We are not debating
Mr.
whether the
Mr.
law
Hassan,
is good
Mr.
or bad.
Hassan,
We are,
Mr. Hassan,
If I may request
Fine.
my distinguished colleague that let Mr. Hassan at least address what one of us have asked, because otherwise we won't.
my
If you can-
question actually is totally related to what has been asked. In the context of access to justice, I had previously asked that when a full court sits, the right of appeal is now not available to the petitioner. If the objective of the law was to give access to justice, and the response of the federation is that, well, when the committee decides that a full court should sit, then there's no right of appeal. Does that bar the right of access to justice? Is this a substantive right that is being prevented? Or can we just say that the power that was vested in the Chief Justice, to that extent, it was incorrect, but now that the committee will decide that a bench of 10, 11, or 12 will sit, and so the right of appeal is blocked. Does that affect the right of access to justice?
that your leadership is a very pertinent question. That, in my humble opinion, it does. But I have an answer to that, howsoever irrational that argument may appear. But maybe the framers of the constitution did not have in mind that that could be a solution. But there is a solution in the constitution which could perhaps, in a very let's say, extraordinary situation, may be resorted to by the Honorable Chief Justice if a full court hears. And that's contained in Article 186. 18, let me just find it out. Where there is a power, if there are reasons, substantial reasons, the Honorable Chief Justice can actually increase the strength of the Honorable Supreme Court.
That's a different situation.
yes,
In
but-
fact, what by not giving the right of appeal, it basically means either the Supreme Court can never sit as a full bench and can never sit as a 10 or 11, 12-member bench. That is one way of looking at it, because that ability of the court to constitute its bench, a larger bench where required, is now blocked if the right of appeal has to be given meaning.
The right of appeal under Article 185 of the Constitution is itself given what could be a right of appeal. And in fact, that is one of my arguments when I'll come to that provision, that Article 1853 does not actually empowers the Honorable Supreme Court in all other matters which are not mentioned there to have a direct right of appeal. It is only by way of special leave to appeal. So there is a distinction that perhaps the drafters of this legislation may not have appreciated. But let me come to your Lordship's question. In fact, there is another question which leads to what your lordship is saying is that what I'm saying is, howsoever good the law may be, it has to follow a certain provision. Whatsoever, we don't doubt the intentions of the parliament. Parliament is of course supreme. Supreme Court is, I believe, the supreme thing over the Supreme Court and the parliament is the constitution. The Honorable Supreme Court is bound by the constitution, the parliament is bound by the constitution. And one of the points that I have mentioned later on is that the oath of offices, all the oaths, whether it's of the Chief Justice, President, Prime Minister, parliamentarian, they have three common words: preserve, protect, and defend.
जरा पढ़ लें.
The constitution, oaths mein. So there is a duty of everyone who takes an
पढ़
oath.
लीजिए.
जी. My lord, schedule 3, oath of office, president.
प्रेसिडेंट का नहीं, तो जजेस का पढ़िए.
Judges का पढ़ देते हैं, my lord.
जी, ये क्या आप जो आर्गुमेंट डेवलप कर रहे हैं जरा बताएं, तो इसकी बुनियाद तो रखिए पहले.
My lord, बुनियाद
पढ़िए ना,
जी.
हजूर क्या पढ़ना चाहते हैं उसमें से.
Chief Justice of Pakistan of the High Court or Judge of the Supreme Court of the High Court, Articles 178, 194. I, so and so, do solemnly swear that I will bear true faith and allegiance to Pakistan, that as Chief Justice of Pakistan or a judge of the Supreme Court of Pakistan or Chief Justice or a judge of the High Court for the province or provinces of, I will discharge my duties and perform my functions honestly, to the best of my ability and faithfully, in accordance with the Constitution of the Islamic Republic of Pakistan and the law. So the
ये जो
Constitution.
लफ्ज हैं, 3 लफ्ज एंड द लॉ, ये जरा मद्देनजर रखिए.
People.
और आगे बताइए
जी.
पॉइंट आपका क्या है.
That I will abide by the code of conduct issued by the Supreme Judicial Council, that I will not allow my personal interest to influence my official conduct or my official decision, that I will preserve, protect, and defend the Constitution of the Islamic Republic of Pakistan, that in all circumstances I will do right to all manner of people according to law, without fear of favor, affection, or ill will. May
आप
Allah.
बताइए क्या पॉइंट आप.
Malad, the point is this, that the Constitution has demarked the powers of the Parliament.
नहीं नहीं, आप आइन के ओथ की बात कर रहे
जी,
थे,
मैं
अब
ओथ-
आपने उसको अधूरा छोड़ दिया
नहीं
आर्गुमेंट
Malad,
को.
उधर नहीं छोड़ा, मैं आ रहा हूँ उधर.
उस बहस को पूरी
दो-
मुकम्मल तो कर लें कि हमें समझ तो आ जाए आपकी बात.
Malad, the Parliament.
पार्लियामेंट की बात इसमें कोई आ ही नहीं रही ओथ में.
मैं ओथ में Malad, Parliament की अगर आप members की oath देखें, उनमें भी जो मैं argument ले रहा था, preserve, protect, and constitution. So it is equally incumbent upon the Parliament to follow what the Constitution says. The Constitution has given them
तो
power of
इसमें
legislation.
कोई दो राय हो सकती
under-
हैं, इसमें कोई दो राय हो सकती हैं.
Malad, 142 में or read with entry 55, they have a certain limitation.
हसन
on
साहब
which
देखिए,
legislation
देखिए
can be
आपको हम पूरा आपकी कदर करते हैं और सुनेंगे.
made. Malad, I'm
मगर
grateful.
अगर आप दलाइल ही नहीं दे रहे हैं, आपने ओथ को टच किया, अब आप दूसरी बात चलेगा, या
Malad,
इस बात को
I'm
छोड़ दीजिए,
trying
कोई
to
और बात बताएं.
answer the
मुझे अभी
question.
तक मैंने कलम इस्तेमाल नहीं किया, मैं लिखूं क्या आपका दलाइल समझूंगा तो लिखूंगा ना.
Malad, let me then proceed the way I have proceeded rather than,
आपने ओथ का जिक्र किया, मैंने कहा और पढ़ दीजिए, उसमें एंड लॉ लिखा हुआ है, आप वजाहत नहीं कर रहे हैं उधर.
Malad, मैं ये सिर्फ आपको कह रहा हूँ कि इसमें the Honorable Supreme Court has to remain within the constitutional framework. The Parliament has to remain within the
अगर
constitutional
जब मार्शल
framework.
लॉ लगते हैं तो सब हथियार फेंक देते हैं.
जी.
फिर जब मार्शल लॉ लगते हैं फिर सब हथियार फेंक देते हैं. और फिर यहाँ इस कमरे में कितनी तस्वीरें लगी हैं जो फिर वो ओथ भी भूल जाते हैं, फिर आप लोग भी भूल जाते हैं, सब कुछ ठीक होता है. मगर जब पार्लियामान कुछ करे तो उससे मीन में खें फिर हो जाती है शुरू.
Malad,
वहां
Parliament.
भी जरा सर उठा लिया करें ना, हम नहीं मानेंगे ये बात को.
Malad,
आप आया करें, वहां भी
जी,
पिटिशन लाया करें ना.
ये लेकर आए ना Malad, इसीलिए. Let
नहीं
it be a-
ये मार्शल लॉ नहीं,
a first
ये एक
drop of
पार्लियामान
rain,
ने
my lord.
कानून
Let it
फैसला
be a
किया.
first drop of rain.
ये बताइए,
तो आप बता ही नहीं रहे ओथ की बात हुई, आपका आर्गुमेंट
ये
खत्म.
बताइए,
नहीं Malad, खत्म नहीं Malad,
नहीं,
oath
आप
oath में Malad.
एग्जैक्टली इस पे आ जाएं. पार्लियामेंट की
Lord,
कॉम्पिटेंस
मैं
है
आंसर
कि
कर
नहीं
दूं
है?
अगर अभी इजाजत
नहीं,
दें तो.
पार्लियामेंट की कॉम्पिटेंस है या नहीं है?
Malad, नहीं है.
नहीं, वो बता दीजिएगा कैसे नहीं.
Malad, आप 142 देखें, 142 को देख लीजिए.
Hmm.
142 के अंदर subject matter of federal and provincial laws, subject to the constitution, then it again says subject to the constitution. So this is restricted power. The Majlis Shura Parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. Now, if 142A is read with NP 55, it does not give them any power which controls the procedure, because that's a constitutional power under
आर्टिकल
191.
55 आइटम 55 में है ना, आप वो पढ़ लें,
मतलब
अब उसका तशरीह की बात है
जी
उसकी।
मतलब इसको सी भी पढ़ लें हम, अगर
आप जो मर्जी पढ़ना चाहें, मतलब
142 के ऊपर आए हुए हैं, तो सी में देयर इज अ स्पेसिफिक प्रोहिबिशन ऑन दैट आल्सो, इसको भी मद्देनजर रखना जरूरी है। Subject to paragraph B, the provincial assembly shall and Majlis Shura Parliament shall not have the power to make laws with respect to any matter not enumerated in the federal legislative list. So everything revolves around the
अच्छा, एक
federal
चीज आप ये बहस कर रहे हैं कि अगर वो लिखा ना हो, अंदराज ना हो फेडरल लेजिस्लेटिव लिस्ट में, तब पार्लियामान उसके मुतालिक कोई कानून नहीं बना सकती है, हाँ या ना?
मतलब that would be subject to your lordship's
भाई
interpretation.
आपकी क्या राय है?
मेरी राय
हमें अपनी राय पता है, आप अपनी राय बताएं।
Very honestly, the entries are just a guideline. It can be interpreted by your lordship.
भाई आपकी राय
I am here
पूछ
to
रहे हैं।
assist this honorable court. I am not here to win or lose the case, my lord. I
भाई
have
तो
to assist.
आपकी राय क्या है, असिस्ट कीजिए ना।
My lord, मेरी राय ये है कि these words of 55, अगर आप इजाजत दें मैं पढ़ देता हूँ. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplementary powers. इस wording में even with a
अच्छा एक सेकंड, इनकी जो बहस है अदर साइड की, इनने जो नोट्स फाइल किए उन्होंने ये फरमाया है कि हम आपके हकूक सुप्रीम कोर्ट के सलब नहीं कर रहे हैं या कम नहीं कर रहे हैं, हम इनको बढ़ा रहे हैं। पहले 3 लोग या 5 लोग या पूरी जो भी 5, 6, 7 की बेंच सुन सकती थी एक केस, अब हमने एक अपील का भी इख्तियार दे दिया है। तो ये पॉइंट आप उधर ले जा रहे हैं ना, तो इसमें हम तो अपने पास तो अपील नहीं सुनेंगे, आप ही फैसला करेंगे। तो इसमें आप बस आपका कहना है कि जो एक दफा सुप्रीम कोर्ट ने फैसला कर लिया वो हतमी होना चाहिए, उस पर कोई अपील नहीं होना चाहिए, ये आपका मौक़िफ़ है?
नहीं, मेरा ये मौक़िफ़ बिल्कुल नहीं है।
तो फिर समझाइए।
जो मेरा मौक़िफ़ ये है, जो भी आप राइट दें, जो भी आप लॉ बनाएं, इट हैज टू फॉलो what is provided in the constitution. अपनी मर्जी से पार्लियामेंट जो है whatever they think is right,
नहीं, तो पार्लियामेंट ये कह रही है सुप्रीम कोर्ट को मजीद इख्तियार दे रहे हैं।
तो वो कॉन्स्टिट्यूशन को फॉलो करें, कॉन्स्टिट्यूशन
नहीं
को
तो वो
अमेंड कर लें।
उनकी नजर में अब आपने पिटीशन फाइल की ना, उनकी नजर में उन्होंने सही किया है और उन्होंने मजीद एक फोरम दे दिया है। ठीक है, 3 लोगों ने फैसला कर लिया, क्योंकि अब आप अगर हिस्टोरिकली इस बात को कोई बात ही नहीं कर रहा है, हिस्टोरिकली अब बात को देखें तो बहुत तनकीद की है वकीलों ने बिलखुसूस, और जिसको कहते हैं ना सोशल समाज ने भी, कि सुप्रीम कोर्ट ने बेख्तियार इस्तेमाल किए हैं 184(3) के तहत इख्तियारात। तो इसमें बहुत से लोगों के पर्सनल हकूक, एक होता है बुनियादी बड़ी बड़ी बातें कि ब्रिक किल्न वर्कर्स नहीं होना चाहिए, ऐसे नहीं, वो आप उन मामलों में भी चले गए हैं, इलेक्शन मैटर्स में चले गए हैं, रेट ऑफ वो क्या होना चाहिए, शक्कर की प्राइस की क्या होना चाहिए। तो अगर किसी को ये आपका फैसला नहीं पसंद आए तो कोई कुछ कर ही नहीं सकता है, बस हतमी हो गया। तो उनका ये कहना है कि अगर सुप्रीम कोर्ट अपने हदूद में रहती, पहली बात आपने हदूद की तजावुज किया है, इसलिए हमने ये जरूरी समझा कि हम कानून बनाएं और आपको याद दहानी करवाएं, मगर आप अगर याद दहानी नहीं करते हैं तो आप ही लोग, एक इस पे नजरसानी का बहुत हदूद कम होता है, एक आप इस पे अपील सुन लीजिए, हो सकता है वही फैसले पे हम मोहर लगा दें और कहें जी बड़ा उम्दा फैसला था। ठीक है, तो इससे एक आम शहरी के हकूक पे जो आप खड़े हुए हैं ना हमारे सामने शहरी की हैसियत में, आपकी सेहत पे क्या असर पड़ रहा है। आप सपोज आप किसी चीज में आते और आपके खिलाफ फैसला हो जाता है 184 में, तो आप तो सर पीठ जोड़ने लगते कि एक हक, बुनियादी हक, हकूक अपील का तो दुनिया के हर आइन और कानून में दिया गया है, आपने तो एक कानून का हक भी हमें नहीं दिया है। तो फिर आपको क्या सेहत पे असर पड़ रहा है? हमारे सेहत पे शायद असर पड़े कि हमारे एक दफा हमने कह दिया बस हर्फ आखिर है।
मतलब आपने क्योंकि मना किया था कि इधर उधर हिस्टोरिक कॉन्टेक्स्ट में नहीं जाना, मैं नहीं गया, लेकिन आई विल
इससे-
आंसर टू योर
इससे-
लॉर्डशिप
और
क्वेश्चन.
देखिए
Because
हर
I am-
चीज
I am
को
answering.
देखना चाहिए
I am
कॉन्टेक्स्ट में.
answering.
जी.
I am answering this question. My lord,
Learned
this
counsel.
if I may be permitted, this is not the first time that a question of constitution of benches has been raised. The earliest case that I was able to find was Hamid Sarfaraz case, where there was an allegation that the bench comprised from a particular region. So my argument is there have been substantial constitutional amendments, and one of the major constitutional amendment was 18th constitutional amendment. All those cases where these allegations and the public outcry and everything was before the parliament, they chose not to amend the constitution or article 191. So this is not for your lordship to come and then say
आप
that,
मेरे सवाल का तो जवाब दे ही नहीं रहे हैं बिल्कुल.
मतलब यही उसका जवाब है कि जो आप आउट क्राई की बात कर रहे हैं कि लोगों ने कहा आपको
नहीं,
राइट
मैं
दे
आपको
रहे
बता
हैं.
रहा हूँ आपको नुकसान क्या होगा, आपको क्या नुकसान होगा कि एक अपील
Because
आपको हक मिल
the
जाए अपील का.
constitution is not being followed, that is a major नुकसान.
आपको
that-
तकलीफ हो रही है इससे.
मतलब मुझे से हो रही है, because then the Supreme Court will swing after every year. Every time a new Chief Justice will come, there would be no certainty of the decisions. There would be no certainty of
Learned
benches
counsel.
that will affect the socio-economic rights of the
अच्छा,
Pakistan
एक सेकंड ठहरिए,
people
एक सेकंड
also.
ठहरिए.
Learned
ये
counsel.
एक सेकंड. अब
बताइए।
ये हम काम ऑलरेडी कर चुके हैं. इस सुप्रीम कोर्ट ने कितनी दफा मार्शल लॉ को इंडोर्स किया है. फिर एक जजमेंट आया था कि जितने ये पहले जजमेंट थे सारे गलत हैं और आइन पे पाबंदी होना चाहिए. ठीक है, तो अगर आप कहते हैं कि नहीं, आप उसी लकीर पे अटके रहे हैं, तो आप कह रहे हैं अगले मार्शल लॉ का दरवाजा आप खुलवाना चाहते हैं
मतलब मैं
हमसे.
ये कह रहा हूँ कि everything has to be come within the honorable
Learned
Supreme Court.
counsel. Learned
The honorable
counsel.
Supreme Court has to sit down
Learned
together
counsel.
and come and
Learned
maybe amend
counsel.
their rules,
Learned
amend the
counsel.
laws.
Learned counsel. ये बताइए, इंसाफ तक रसाई अगर पार्लियामेंट ने देनी हो हक, उस पे लेजिस्लेट नहीं कर सकती है पार्लियामेंट.
बिल्कुल कर सकती है, बिल्कुल
नहीं,
कर सकती है,
सुन
बट
ले।
लॉ को फॉलो करके,
सुन तो
कॉन्स्टिट्यूशन
ले,
को फॉलो
सुन
करके.
तो ले. आप ये कह रहे हैं कि इंसाफ तक रसाई के लिए कॉन्स्टिट्यूशन अमेंड करना पड़ेगा पार्लियामेंट.
मतलब इधर कॉन्स्टिट्यूशन ने ये कहा है कि प्रोसीजर ऑफ द सुप्रीम
ना
कोर्ट.
सुन लेना, एक राइट ऑफ अपील दी है, that provides access to justice and right to appeal relating to a jurisdiction which already is vested in the Supreme Court. Up that remedy, would that not be covered?
there are two
See,
aspects to
you are
it.
saying-
Mr. Hassan
देखिए मैं
Irfan,
आपको सर मैं अगर
the
इनको
question
सर
is-
राइट ऑफ अपील बाय अ स्टैट्यूट टू अ सुप्रीम कोर्ट
मैं
इज अ
समझ
डिफरेंट
गया, आप
थिंग.
ये कह
The
रहे हैं
right of appeal from an original jurisdiction is a totally different thing.
ये
ये
कह रहे
बहुत
हैं
बहुत से
कि
सारे
ये-
लॉज हैं जिसके
These
अंदर
are
अपील
two
प्रोवाइड की गई है
different
सुप्रीम
things.
कोर्ट में.
जी.
बहुत से ऐसे लॉज हैं जिसमें डायरेक्टली
बिल्कुल,
अपील,
बिल्कुल
कंटेंट ऑफ
ठीक है.
कोर्ट ऑर्डिनेंस में नहीं है
और
अपील.
एक्सेस ऑफ
तो आप
जस्टिस
कहें कि उसकी भी कॉन्स्टिट्यूशन में आर्टिकल 204 के साथ अपील होनी चाहिए थी सुप्रीम कोर्ट में.
देखिए मैं कुछ और कह रहा हूँ. मैं ये कह रहा हूँ कि जहाँ
Mr.
पे
Hassan Irfan, just to add to what my learned brother has said, the basic question is not whether an appeal can be provided or appeal cannot be provided. The basic question is which procedure, which entity would provide that
Absolutely.
appeal. Where the Constitution needed to provide an appeal, it provided an appeal.
absolutely
184 is original jurisdiction. Okay. उसकी अपील अगर कॉन्स्टिट्यूशन ने 185 में प्रोवाइड नहीं की तो कॉन्स्टिट्यूशन का मंशा नहीं था वो अपील प्रोवाइड करना.
बिल्कुल.
कॉन्स्टिट्यूशनल ज्यूरिसडिक्शन जिधर सुप्रीम कोर्ट एक्सक्लूसिव कॉन्स्टिट्यूशनल ज्यूरिसडिक्शन एक्सरसाइज करता है, उसमें अपील थ्रू ऑर्डिनरी स्टैट्यूटरी लेजिस्लेशन डिस्पेंसेशन नहीं हो सकती. अगर ये मंशा है कि 184(3) की अपील प्रोवाइड की जाए, अब जो ओरिजिनल लॉ मेकर के जहन में डिफरेंट कॉन्सेप्ट था, then the only way to interfere in or provide an addition to or provide an adjunct to 180
प्रैक्टिस एंड प्रोसीजर एक्ट पर सुप्रीम कोर्ट में समाज जारी। चीफ जस्टिस काजी
कॉन्स्टिट्यूशन को एक तरफ रखते हैं, कॉन्स्टिट्यूशन जो नहीं भी प्रोवाइड करती, आप कहें जी मेरे पास लॉ की पावर है, मैं एक अपील नहीं मैं 4 अपीलें दे देता हूँ। Then
That
where
is not
does the
possible.
constitution
That
goes?
would be deviating from the constitutional mandate. और मतलब एक point और 184
Mr. Hassan,
whether incompetence of the parliament can be condoned on the ground that the intention of the lawmaker is good?
मतलब can you repeat that the question?
Whether the incompetence of the parliament can be condoned on the ground that the intention of the parliament is good?
No, my lord. I think the intention has got nothing to do with following the
So
constitution.
whatever may be in the law, whether it provides access to justice or provides extra remedy to the public at large, it cannot be treated as a good law unless the parliament has the competence to do it.
Legislative competence. That is absolutely, that is a very clear rule throughout the world in all
Mr.
circumstances.
We could look at
Aapse-
entry 55,
aapse-
where the competence is derived from. Entry 55 says that so far as the Supreme Court is concerned, to such extent as expressly authorized by or under the Constitution, the enlargement of the jurisdiction. Which means that it is something that is provided under the Constitution, and it is that jurisdiction which is being enlarged. Is that correct?
That's correct.
So आप ये बताइए कि जो provisions दिए हैं power 2, 3, 4 में, 6 में, 7 में, ये constitution में कहाँ दिया हुआ है जिसकी enlargement हो रही है? All that the law can do, the legislature can do is enlarge something that is provided by or under the constitution. ये वाली power कहाँ दी है constitution
तो नहीं
में
दी, मतलब
जिसको वो enlarge कर रहा है?
This is what my whole argument is, because the argument that I actually started to begin was that 1843 does not start with the word subject to constitution or subject to law.
It's not just
no,
184. It's any provision of the
complete.
constitution.
So if we uphold this law, then it means that we have to read into 184 saying subject to law, the Supreme Court has these powers, which is not possible, by any stretch of interpretation or stretch of imagination. That will tend amount to amending the constitution or rewriting the constitution, because the framers of the constitution have not placed any fetter on the power of a petitioner to come and bring a petition. And there is also a second power under 1843, which is a power of the Supreme Court to make an order.
अच्छा, आप जो बात कर रहे हैं अमेंडमेंट ऑफ द कॉन्स्टिट्यूशन की, एक जजमेंट है जफर हादी शाह साहब का केस जी, वो पार्लियामेंट तो छोड़िए, उन्होंने तो एक फर्द वाहिद को सुप्रीम कोर्ट ने इख्तियार दे दिया। आप उससे इत्तेफाक करते हैं? आप उससे इत्तेफाक करते हैं?
मैं नहीं करता,
और सपोज अगर सुन लीजिए पूरी बात, और अगर आप उससे इत्तेफाक नहीं करते हैं तो ये बड़ा अच्छा कानून नहीं बना है पार्लियामेंट ने कि हम उसको रिविजिट कर सकें, अगर वो रिविजिट नहीं हुआ होता आज तक, या वो फर्द वाहिद हावी हो गया कॉन्स्टिट्यूशन पे, इस सवाल का जवाब दीजिए।
If I may put it this way, certain decisions of this honorable court in the past does not lead to a situation where the same mistake should be repeated again.
फिर आप हमारे पास क्या कर रहे हैं? नहीं सर, ठहर जाइए ना, ये मफरूजों में ना जाइए। हम देखिए, मैं जो बात करता हूँ मैं मफरूजों की कम करता हूँ, हकीकत की जबात जाता है। पिछली तारीख पे हमने मौजूद थे, रिको डिक का केस का बताया, ठीक है, रिको डिक 3 मेंबर बेंच ने फैसला किया था, ठीक है, कोई दरवाजा नहीं था उसको खोलने का सिवाय एडवाइजरी जुरिस्डिक्शन, एक स्ट्रेच जुरिस्डिक्शन आप समझ लें उसको, वहां इस्तेमाल किया गया। इस तरह का केस अब आप पाकिस्तान की तारीख से शुरू हो जाइए, मौलवी तमीजुद्दीन से शुरू करें, डोसो से शुरू करें, किससे शुरू करें, नुसरत भुट्टो की बात करें, और ये जफर हादी शाह की बात करें, ये इन्होंने तो आप किधर हैं, आप तो इधर बारीकियों में जा रहे हैं। उन्होंने पूरे शख्स को कह दिया तुम आइन से जो खिलवाड़ करना चाहो हम आपको दे देते हैं इख्तियार। ये इख्तियार आप बार बार आइन और कानून की बात कर रहे हैं, तो ये तो क्या जजों ने नहीं हल्फ तोड़ा अपना जब उन्होंने ऐसे फैसले किए? आप खुल की बात कीजिए ना, ये पाकिस्तान की तारीख को आपके नजरअंदाज कर दें। हमारे एक बहुत फलसफाई बहस में पड़ जाते हैं, हम पाकिस्तान को नजरअंदाज नहीं करते, पाकिस्तान के साथ जो खिलवाड़ हुआ उसको नजरअंदाज नहीं कर सकते। हमें देखिए, पार्लियामेंट की कदर करना चाहिए, अगर कोई कानून, ये मेरी जाती राय आप समझ लें, है तो वो आप उसको दिखाइए, ये लोगों का इसमें नुकसान है, ये आइन के शिक के बरक्स है। मेरे दोस्त ने बार बार फरमा रहे हैं आप प्रोसीजरल बात पे तो कोई कर नहीं रहा है, आप लोग अगर आप मेरिट से बात कर रहे हैं, क्योंकि आप अभी तक अटैक भी नहीं समझ आए कि आपको पूरा पसंद नहीं है, उसकी कोई शिकें नहीं पसंद हैं, कोई प्रोसीजरल मैटर्स हैं, कुछ मैटर्स हैं जैसे कि जो आप 14 दिन में फैसले कर लें, ठीक है। अब ये यहाँ बैठे हुए हैं हमारे सदर, ठीक है, ये मौक़िफ़ पहले कहते थे कि जी फलां डॉक्ट्रिन है, केस लगता ही नहीं है, ठीक है, खुल के बात कीजिए ना, या तो ऊपर पीछे हट जाएं। वो कहते थे ये डॉक्ट्रिन है, मैं साहब का नाम नहीं लूंगा, केस ही नहीं लगा। ये आइन के मुताबिक है, ये कानून के मुताबिक है, ये क्या हल्फ के मुताबिक है। जब आप ये सारी बातों को नजरअंदाज कर देंगे, फिर आप ये भी देखिए कि दुनिया में हमारा जो इंटरनेशनल एजेंसीज वो करती हैं, सर्वे करती हैं, हमारा नंबर किधर है। हम नंबर नीचे ले जाना चाहते हैं कि नहीं, फर्द वाहिद का अख्तियार कम ना हो, और फर्द वाहिद ने इस मुल्क की तबाही की है। मार्शल लॉ डिक्टेटर्स हो जाए या कोई और हो जाए, वो फर्द वाहिद होते हैं, वो इज्तिमाई सोच वाले नहीं होते। वो कहते हैं मैं खुद फैसला करूंगा, आपस में नहीं करूंगा। हम आपस में फैसले करने वाली बात है। आपको क्या फिक्र पड़ रही है कि हम कैसे फैसला करें आपस में, हम 1 करें या 3 करें। अब 5 की बेंच सुन ले एक आईनी मसले को। एक चीफ जस्टिस गुजरे, उन्होंने कहा पहले 5 सीनियर चीफ जस्टिस जजेस सुन लें आईनी मसाइल को, ठीक है। इनका एक तर्ज कार है, अगर वही पार्लियामान कर दे, ओहो गुनाह हो गया। आप कर सकते हैं तो अगर 5 कर सकते हैं, फिर वो 2 भी कर सकते हैं, फिर वो 3 भी कर सकते हैं, फिर वो कह सकते हैं कि मैं जिस मर्जी जज को बिठाऊं वो भी मैं कर सकता हूं। तो देखिए, ये आप जो बात कर रहे हैं ना, सदर ने ये कह दिया, अखबार की खतीम पढ़ लें, ये तो हमारी तारीख है, इसको भी मद्देनजर रखिए, और फिर आप जरा दलाइल दे दें कि ये पार्लियामान को आपने एकदम उस पर अटैक कर दिया कि जी उसको आप इम्प्यूट कर रहे हैं कि जी उन्होंने कोई गलत बदनीयती से। आपसे पहले चौधरी साहब ने कहा ये जी पर्सन स्पेसिफिक है, मुझे इसमें पर्सन किसी का नाम नहीं जिक्र आ रहा है, ना किसी का तस्करा है। हो सकता है आप ही कल इसका फायदा उठा के हमारे सामने आ जाए किसी केस में। तो आप जरा इतना नैरो विजन ना रखिए, जरा पूरा ब्रॉडन विजन कर लेना। और हमें जो आईन और कानून की जो बातें करते हैं, तो हमारे सामने एक सबसे बड़ा हदफ होना चाहिए, लोगों के फायदे की बात है या लोगों के नुकसान की। चीफ जस्टिस के फायदे को आप छोड़ दीजिए।
Well, this is
Yeah,
not
Leonard-
about the Chief
Leonard
Justice. I have got
Counsel-
no lost love
Leonard
for any
Counsel-
Chief Justice.
Leonard
Let me put
Counsel-
it this way.
I'll draw your attention to entry 58. So as I've understood your argument, that the parliament is bereft of jurisdiction if it wants to legislate in the context of Article 10A या इंसाफ तक रसाई, यानी वो आम शहरी के लिए बिल्कुल ये मान नहीं कर सकती। As I have correctly understood your point.
Lordship, let me first address, I will come to your Lordship's question. Lordship, I have not used a single word that there was any, or nor I have imparted any insinuation on any one parliament or anything else. Your Lordship's point that what has happened in the past, in fact, our past is unfolded for us for a better future. So your Lordships are sitting as 15-member bench. Your Lordships can undo whatever the cases have been passed. What your Lordship is perhaps
Excuse me, sorry,
suggesting-
we cannot. The appeal gives us the right to do it. आप कह रहे हैं we can, अभी तो आप contradiction कर
No,
रहे
no,
हैं।
no, no. ये आपने तो पिछले जजमेंट्स की बात है। मैं जो आपको
Yes, sir.
सबमिट कर रहा हूँ,
Yes,
वो
sir, if I may ask you,
एक मैं सिर्फ
just
सर,
one minute.
जी सर।
The first time that this court upheld martial law was Doso versus State. In Asma Jilani, Doso versus State was set aside on as being not good law, as having made Pakistan a
So the
perfectly
speaker
good
may
country
kindly
into a
put-
laughing stock. Now the question is, when the court did that in Asma Jilani, was the court hearing an appeal against Doso versus State?
Lordship, I didn't get your question. Maybe if you put your speaker on.
The speaker is on. My question to you is that the first time that this court upheld martial law was Doso versus State. In Asma Janani, that judgment was declared not to be correct law. When deciding Asma Jalani case, was this court hearing an appeal against Doso? No.
No.
The court, if it wants to correct its past errors, it can do so. It doesn't need to have this kind of an appeal in order to be able to do so. The court should have the stature if it wants to, if it thinks an error has been made, it can correct that error. There are many ways because we are a common law jurisdiction. We are driven by common law, by precedent. Doso versus State, Grand Norm, Tellson's theory, that was all precedent. Asma Jilani, totally different case, said wrong. That was wrong law. In the future, the court can do that. But I think if I may, if you permit, I would like to ask you a question on 184.3, what you, because you read it out to us. Now you read out the word, the court shall, if it considers. My question to you is, this consideration, is that judicial power or is that administrative?
No, that's a judicial power. That's what my argument is.
Therefore, it seems to me, because you see, it's very interesting that one of our learned colleagues in a number of, well, not number, but in few, more than one chamber appeals, he has made an order that the question of maintainability of a petition under Article 184.3 is adjudication. It is exercise of judicial power and therefore the registrar can't do it. As I read section 3, it seems to me that that is what section 3 is conferring a power on the committee. Now, I read the decision of my learned and distinguished colleague to be a statement of principle. And if this principle is correct, surely it seems to me, but you can correct me if you think that I'm wrong. If this principle is correct, then issue of maintainability, whether decided by the registrar of this court or whether decided under cover of this act by a panel of judges, no matter how senior and eminent those judges, it is still exercise of administrative power. It is not adjudication, which maintainability requires because of the word considers. So would it be therefore correct to suggest that the use of this word considers, which necessarily means exercise of judicial power by the court, Section 3 is in direct conflict with this requirement of Article 184.3, and therefore, perhaps on that very short ground, is perhaps unconstitutional.
Absolutely. And there are scores of judgments. As I said, I'm not going by the
Learned
judgment that the
counsel-
constitutionality has to be decided by the court
Learned
itself.
counsel-
That's the function of the court.
If I may take this a little bit
Learned
further,
counsel,
if I may take just, if I may take,
I'm sorry.
no, answer the question.
Please. my lord.
Learned counsel, so on the same argument, the power that earlier vested in the Chief Justice to consider and pick and choose whatever petitions he wanted to place before the court, that was also unconstitutional?
Lordship, if I am too small a fry to raise this argument, but I think I have to raise this argument that your lordships are proceeding on a premise that this bench or the committee of 3 judges would be able not to pick and choose. And it is, if past experiences are any learning curve for us, it will not be difficult for us to imagine even a committee where the 3 judges are on the same page, as they call it, and then still just decide to
but,
fix the
देखिए,
benches,
ऐसी
then
बात-
that would be going on a mafruza, if your
No, no,
lordship would say.
आप मफरूजों की बात कर रहे हैं, आपकी बात बिल्कुल सही है कि हम तीनों मिल करके आपके खिलाफ फैसला कर रहे हैं जी इरफान साहब के केसेस लगाने ही नहीं है। ठीक है, सुन लीजिए, आप कह सकते हैं 5 की कमेटी बनाए, वो भी बना सकते, कर सकता है, पूरा फुल कोर्ट करें, वो भी कर सकता है, मगर ये जो कानून है इसकी सिमत सही है या नहीं, आप मद्देनजर रखिए जो हो चुका है पाकिस्तान में। अगर आप कहें नहीं, मैं तो एक मफरूजे पे बात करूंगा, पाकिस्तान की तारीख को नजरअंदाज करना चाहता हूं, तो वो एक अलग बात है। तो इस तरह तो अगर आप कहें तो, मगर वो अंग्रेजी में कहावत है सेफ्टी इन नंबर्स, ठीक है, हो सकता है हमें बड़ा इख्तिलाफ हो जाए, ठीक है, हो सकता है हम, आपने जैसे लफ्ज इस्तेमाल किया, सेम पेज पे हों, मगर ये बेहतर है या वो बेहतर है? तो मफरूजों पे ना चलिए, आप सिर्फ बताइए। एजाज साहब बार बार आपसे 2 बुनियादी सवाल उनके वहीं के वहीं रह गए कोई इस तरफ जा रहा है, कोई इस तरफ जा रहा है, उन सवालों पे अगर आप फोकस करें तो जरा आप भी आसानी होगी। आप और ये बहुत मुश्किलात पैदा कर रहे हैं।
मेरा
Mr.
बार-बार
Hassan,
वही जवाब
Mr.
है, it
Hassan,
has to follow the law
Mr.
and the
Hassan,
constitution.
Mr. Hassan, I'm right here.
Sir.
Just following that, Justice Ijaz had already quite, succinctly pointed out the question, and we're going all over the place. Let's just get done with the competence. To me, competence revolves around Article 199, 191, entry 55 and 58. So direct question to you is there a parliamentary competence under 191 itself? Because competence can come two ways. One is through the Constitution itself, or the other is through the entries in the Constitution. So the direct question is, under Article 191, can the Parliament legislate regarding practice and procedure? We'll come to the appeal later and see whether at all it's part of practice and procedure or it's a substantive separate provision. Usko chhod dein. अभी सवाल आपसे पूछ रहे हैं कि क्या 191 directly or read with 58 gives Parliament the power to legislate regarding practice and procedure?
No, my lord.
What's your answer to that?
My short, clear and crisp answer is no.
No, please tell us how.
Ji, how? Because if your lordship would read 142 read with 191,
Right.
so because there is a direct power to the Supreme Court to make rules.
There is
then-
also a
and
power to
it-
the Parliament to make law
to
under
law
191
relating to what?
to the
Relating-
practice and procedure.
It doesn't say so. Where is that? It is, so practice and procedure is not
आप जरा
enlargement
पढ़
of the
लें
power.
191 को एक दफा पढ़ लें।
जी my lord.
लेट्स रीड 191, फिर बताएं कि क्या वो पावर दे रहा है या नहीं दे रहा है।
191, rules of procedure. Subject to this constitution and the law, the Supreme Court may make rules regulating the practice and procedure of the court.
So the question is that it says that the practice and procedure could be regulated by the Constitution itself, by the law given by the Parliament, or by the rules made by the Supreme Court. There are three different sources
Yes.
which could regulate the
Yes.
procedure. And nothing is redundant in the Constitution. So there could be a parliamentary act passed by the Parliament which could regulate the practice and procedure.
Right.
And any rules would be subject to the Constitution as well as to that law. So the law 191 itself is authorizing the Parliament to go ahead and come up with legislation on practice and procedure. And if not, if we were to read it 58, then again, Parliament gets the competence to legislate regarding practice and procedure. That's a separate question. What is practice and procedure? It's a separate question whether at all that legislation then does not pass the constitutional muster as far as fundamental rights are concerned. We'll come to that later. आपसे सिर्फ सवाल ये है कि 191 read with 58 कैसे नहीं पावर देता पार्लियामेंट को कि प्रैक्टिस एंड प्रोसीजर पे कानून साजी करें?
Sir, मैं इसका जवाब आपको देता हूँ. Again, there is a distinction between.
Mr. Hassan, यहीं पे इसको supplement कर
Sir.
लीजिए question को, whether the word law used in Article 191 can be construed in a sense conferring a power on the Parliament to legislate on the practice and procedure of the Supreme Court, or it should be construed in a sense limiting the power of the Supreme Court to frame rules.
Sir,
See, ये आपने एक judgment में the Supreme Court has interpreted what does subject to the Constitution and the law mean. In the context of 191, the power, आप इसको पढ़ें, the Supreme Court may make rules. The power lies with the Supreme Court.
Supreme Court.
और जो subject to law and constitution लिखा हुआ है, उसका मतलब ये है कोई restriction Supreme Court के कोई restriction constitution में या कोई restriction existing law में ना हो तो उसके मुताबिक Supreme Court अपने rules बनाएगा. If there is a restriction in the constitution or if there is a restriction in an existing law, उसके contrary Supreme Court rules नहीं बनाएगा. लेकिन rules कौन बनाएगा?
Supreme Court.
Supreme Court बनाएगा.
और in
ठीक है?
इसको
restriction existing law or existing law they're defined है 267.
सर इसमें
इसको
अगर
इस
हम
तरह ले लें,
Existing
वकील
law
साहब।
में अगर restriction नहीं है, constitution में restriction नहीं है, then the exclusive power to make administrative rules or internal rules or rules of procedure, exclusive power is with the Supreme Court.
सर दिस
It
इज
does not confer jurisdictional or it does not confer competence on the parliament to 191 does not confer power on the parliament to legislate on practice and
आई एम
procedure.
ग्रेटफुल फॉर रेजिंग दिस क्वेश्चन इन फैक्ट आई हैव मेड अ लिस्ट
चले चले बढ़िए बढ़िए आगे।
मतलब इफ आई मे सबमिट
नहीं सबमिट करें, घड़ी को भी देखिए
मतलब
जी।
अगर हमने कॉन्स्टिट्यूशन को बिट्स एंड पीसेस में इंटरप्रेट करना है देन वी मे नॉट बी एबल टू रीच एनी कंक्लूजन इफ वी हैव टू रीड एज अ होल। मैं आपको बताता हूँ कॉन्स्टिट्यूशन
देखिए ये जजमेंट आपने वो देखी है जिसमें
जी,
ये इंटरप्रेट हुआ है?
जी जी मैंने ये आपको रिप्रोड्यूस की है। मैं
अच्छा
सिर्फ
पहली
एक
बात एक चीज मुझे बता दें, आप क्या अग्री करते हैं कि सुप्रीम कोर्ट जो करे वो कर सकती है?
सर मैं एग्री करता हूँ इस चीज से कि सुप्रीम कोर्ट जो करे वो कर सकती है
अच्छा रुक जाइए,
कॉन्स्टिट्यूशन
रुक जाइए,
इसको
जो
हम
रुक जाइए,
ओपन एंडेड ना
नहीं
करें।
नहीं रुक जाइए, मैं नहीं अग्री करता हूँ, ठीक है, ठीक है। और हमारा अनरिटन कॉन्स्टिट्यूशन नहीं है। जिस किस्म के प्रेसिडेंट्स विलायत में बनते हैं, कॉमन लॉ जिसको हम कहते हैं, हमारे उसमें आइन में इंदराज हो गया है। जैसे लफ्ज आ गया ना, डिफेंड, प्रोटेक्ट द कॉन्स्टिट्यूशन, प्रिजर्व द कॉन्स्टिट्यूशन। तो जब ये अदालत, और मैं खुद एतराफ करता हूँ, और जब तक आप एतराफ नहीं करें सलाह हो ही नहीं सकती है। वो आया कोई शख्स आया, जी ठीक है, आप बिल्कुल ठीक है, आइन को आप रोंद लें, आप आइन को बदल लें। तो ये अगर हम इस पे चलें तो फिर इसका मतलब है हर बेंच जब उस वक्त में फैसला करेगी वही लागू होगा। आइन का तो कोई अहमियत रही नहीं। फिर तो जजमेंट लॉ पे हम चलेंगे। आइन को एक तरफ रख दें, क्योंकि आज सुप्रीम कोर्ट का मूड ये है कि मौलवी तमीजुद्दीन केस का फैसला सही है और 4 जजेस जो सिंध हाई कोर्ट का उनका गलत है। फिर मूड हुआ कि जी 200 केस में वैलिडेशन और मार्शल लॉ तो सही है। फिर जिलानी केस में नहीं आज सही नहीं है, नहीं फिर सही हो गया और फिर नहीं सही हो गया। मेरे ख्याल में इससे ज्यादा बुनियादी सवाल तो ये उठता है, आप क्यों नहीं आप हिम्मत पकड़ते हो कहें सुप्रीम कोर्ट गलत थी, क्योंकि आइन के बरक्स या कहिए, हिम्मत कीजिए और कहिए नहीं बिल्कुल, या आप कहिए हम जंगल के बादशाह अंडा दें या बच्चा दें। क्योंकि आप, मुझे लग रहा है आप आखिरी बात कर रहे हैं
सर मैं
ना,
तो कह रहा हूं
आप
कि
ना आप पहली किश्ती में जाना चाहते हैं ना दूसरी किश्ती में जाना चाहते हैं। आप चाहते हैं कि मैं ये आखिरी बात कर दूं जो मुझे जेब नहीं देती, क्योंकि मैंने ऐसा हल्फ उठाया नहीं है।
सर आपने हल्फ उठाया है प्रिजर्व का इंग्लिश का कॉमन मतलब क्या है कि आप कॉन्स्टिट्यूशन, अगर आप वर्ड्स पे जाते हैं और आप स्टारे डिसाइसिस में नहीं जाते
पूछ रहा हूं,
तो
आप
फिर
ही राय दीजिए
फिर
ना।
आप कॉन्स्टिट्यूशन का एक लफ्ज इधर उधर नहीं कर सकते। प्रिजर्व मींस यू हैव टू प्रिजर्व इट, डिफेंड इट, यू हैव टू डिफेंड अगेंस्ट एन अटैक।
और कितना वक्त आप ले रहे हैं अभी आप बताएं।
सर अब मैं क्वेश्चन मैंने मेंस
Learned counsel coming back
सर
to,
अगर आप माइंड वो बहुत सारे उनके क्वेश्चंस थे।
Learned counsel coming back to my Lord Justice Ijazul Hasan's question. ये जो interpretation है 191 की, how do we read into this provision that subject to law means a restriction in the law and that the primacy is to be given to the rules made by the Supreme Court? ये जरा एक्सप्लेन कर दीजिएगा ना
सर। जो 191 की पावर्स हैं दे आर डायरेक्टली कमिंग, जो मंसूर शाह साहब ने भी क्वेश्चन किया था, दे आर कमिंग डायरेक्टली फ्रॉम द कॉन्स्टिट्यूशन। तो वो कॉन्स्टिट्यूशनल पावर है। द क्वेश्चन आल्सो अराइज, कैन द कॉन्स्टिट्यूशनल रूल मेकिंग पावर कैन बी stultified by a sub constitutional legislation? They cannot be, because whatever has to be done, it has to be done through an internal
ये
mechanism।
तो आप दोहरा रहे हैं अपनी बात को, नई दलाइल दीजिए ना।
मैं अगली बात के ऊपर सर एक मैं सिर्फ बात कर लूं, जो जवाब जो था वो, अगर आप कॉन्स्टिट्यूशन
आप इसी कंटिन्यूएशन में सवाल देखें ना, आप ये 191 की बात कर रहे हैं, वो तो जो उसकी ओपनिंग वर्ड्स है सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ, जो मैं समझा एज फार एज आई एम कंसर्न, इसमें तो शायद ये है कि सुप्रीम कोर्ट रूल्स बना सकती है अपने प्रैक्टिस एंड प्रोसीजर के, लेकिन दैट मस्ट बी सब्जेक्ट टू लॉ एंड कॉन्स्टिट्यूशन। लॉ और कॉन्स्टिट्यूशन दोनों पार्लियामेंट बनाती है, पार्लियामेंट का इख्तियार है। उन इख्तियार के तहत, उस लॉ के तहत जो भी रूल्स बनेंगे, हम उस रूल से, उस लॉ से हट के बाहर नहीं जा सकते। क्या इसका ये मतलब नहीं है?
यही क्वेश्चंस तो आप लोगों ने रिजॉल्व करने हैं। इफ द मेजॉरिटी विल
नहीं तो फिर करने तो फिर आप बैठ जाइए, हम कर लेंगे।
मैं
फिर आपकी
आपको
जरूरत
assist-
नहीं है।
मालूम मैं assist-
आप तशरीफ
देखिए,
रखिए फिर।
आप मेरी बात को सुने। The question is this, what I am saying is that 191 को आप आइसोलेशन में नहीं पढ़ सकते। 191 में सिर्फ
नहीं, मगर आप बात ही नहीं समझे। अगर आप उसकी ओपनिंग वर्ड्स देख लें, सब्जेक्ट टू द कॉन्स्टिट्यूशन एंड लॉ, माय लॉ, जरा सुन लीजिए ना। जैसे जमाल साहब ये कह रहे हैं, तो ये एंड लॉ लिखने की जरूरत क्या पेश आई? सिर्फ लिखते सब्जेक्ट टू द कॉन्स्टिट्यूशन, द सुप्रीम कोर्ट में मेक रूल्स रेगुलेटिंग प्रैक्टिस एंड प्रोसीजर ऑफ द कोर्ट। ये लॉ जो दो लफ्ज हैं, इसको हम कैसे इसकी तशरीह करें, ये सवाल है।
सर इसमें एक जवाब तो ये है कि जिस वक्त ये रूल्स बने थे, अगर कोई लॉ मौजूद
हम
होता,
आइन की बात कर रहे हैं, रूल्स की बात नहीं कर रहे हैं।
जी मैं आइन सर, जिस वक्त आपने सुप्रीम कोर्ट रूल्स बनाए थे, उस वक्त अगर कोई लॉ मौजूद होता तो उसके आप फॉलो करते, विच
आपका कहना ये कि
there was no law at that time.
जब आइन बन रहा था उनको ये पता ही नहीं था।
सर the question is this, जिस वक्त आइन
नहीं,
बन रहा था,
आप ये बताएं कि सब्जेक्ट टू का क्या मतलब है? इज दैट एन इनेबलिंग पावर? डज इट गिव कॉम्पिटेंस और इज दैट अ लिमिटेशन? Does that restrict the power? Because the understanding, one understanding is that subject to constitution and the law is where the competence is being derived from. Whereas the other understanding can be that subject to, the prefix subject to is a limitation. Now, the other question that goes with the understanding of law, if law is more than just an act of parliament, and law can mean rules, regulations, ordinances, policies, whatever is in the field of law. So all that will govern the ability of the Supreme Court to make its rules for practice and procedure, because law is much more than, it involves more than just an act of parliament.
if we go by the words which are used in the constitution, an act of parliament is different from the use of the word law.
Which is why subject to becomes relevant.
Relevant
So what does
also,
subject to mean? It
but
means,
if I may be allowed to complete my point of view is that under Article 191, only Supreme Court has been given the power, whereas in the Constitution, if your lordship see Article 67, 72,
Learned Council,
where
Learned
the
Council,
where
जब
a
आप
particular,
देखिए हसन साहब, आप ये
सर,
आप जवाब देते नहीं, आप दूसरी जगह चले जाते हैं।
सर मैं अपनी बात तो मुकम्मल कर दूं ताकि
अगर
आपको
subject to
assistance
का
हो जाए।
meaning बता देना जी, how should we
आपसे
read
सवाल
it?
एक हुआ ना,
सब-
सब्जेक्ट का
सब-
मतलब क्या हुआ?
सब्जेक्ट का मतलब ये है कि कॉन्स्टिट्यूशन में अगर कोई रिस्ट्रिक्शन है तो रूल्स उसको फॉलो
तो
करें।
यही पूछ रहे हैं, है या नहीं? जवाब भी देते
कोई भी नहीं है
हसन साहब, ये रिस्ट्रिक्शन की क्या बात है? कोई रिस्ट्रिक्शन नहीं होती
कोई
इसमें।
नहीं।
सब्जेक्ट टू लॉ, सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ, रिस्ट्रिक्शन का कोई इशू ही नहीं है ना। अगर कॉन्स्टिट्यूशन और लॉ के मुताबिक सुप्रीम कोर्ट रूल बना सकता है। अब ये लॉ आ गया, इसमें भी अगर हम कुछ चाहे तो हम रूल बना सकते हैं, क्योंकि ये लॉ के अंदर कोई चीजें आई हैं, मिसाल के तौर पे उसको रेगुलेट करने के लिए रूल बनाने की जरूरत है। सुन लीजिए, कोई भी सेक्शन ऐसा है, उसके लिए भी हम रूल बनाना चाहें तो विद इन द प्रेमिस ऑफ दैट लॉ, सुप्रीम कोर्ट में रिवाइज द रूल्स बिकॉज सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ। बात समझ आई आपकी?
सर अब क्वेश्चन एक अराइज ये होता है,
तो ये रिस्ट्रिक्शन और इंलार्जमेंट का इशू नहीं है ये, दिस इज द क्वेश्चन ऑफ इंटरप्रिटेशन।
एब्सोल्युटली
सब्जेक्ट टू हर जगह इस्तेमाल होता है। देयर आर सो मेनी वर्ड्स यूज्ड इन द लॉ, सब्जेक्ट टू कॉन्स्टिट्यूशन,
notwithstanding anything contained in the
नॉटविथस्टैंडिंग,
constitution,
नॉन-ऑब्स्टेंटिंग क्लॉज। तो ये जो है सब्जेक्ट टू कॉन्स्टिट्यूशन, बिकॉज सुप्रीम कोर्ट इज द क्रिएचर ऑफ कॉन्स्टिट्यूशन, सब्जेक्ट टू कॉन्स्टिट्यूशन।
yes sir, Supreme Court is not the creation of constitution.
क्या मतलब?
So sorry, आपके Supreme Court
Supreme Court कहाँ से बना है?
जी नहीं, that is right.
कहाँ
Supreme
से
Court
आया
is the
Supreme
creation.
Court?
Supreme Court has been created by the Constitution. That's correct.
सुप्रीम कोर्ट कॉन्स्टिट्यूशन एंड लॉ, जो भी लॉ होगा, चाहे वो कॉन्स्टिट्यूशन में मौजूद हो, लॉ में मौजूद हो, हम उसके मुताबिक रूल बना सकते
बिल्कुल
हैं।
चलेंगे।
तो मेरी अंडरस्टैंडिंग में तो इस लॉ के बाद भी हम रूल अपने अमेंड कर सकते हैं।
सर क्वेश्चन ये है,
अगर कोई क्वेश्चन
ये
ऐसा है,
आप
मिसाल के तौर
बना
पर
सकते हैं,
सुनिए,
बट क्या
राइट
इस
ऑफ
law
अपील
से-
है, राइट ऑफ अपील है, उसके लिए हम अपने रूल में कर सकते हैं कि इस अपील को हम किस तरह हैंडल करेंगे। राइट ऑफ रिव्यू है, हम चाहें तो उसमें अमेंडमेंट कर सकते हैं। ठीक है, तो ये जो है इसका कोई इतना नैरो इंटरप्रिटेशन नहीं है कि सब्जेक्ट लिख दिया तो बस हाथ पैर कट गए, सुप्रीम कोर्ट खत्म हो गया पूरा।
देखिए, that is for your lordships to decide. What my submission
The
is respectfully,
phraseology subject to itself, the phraseology used subject to the constitution means what if there is a restriction in the constitution,
absolutely.
you cannot go beyond that.
Right. It's not
इसी
beyond
तरह
that.
subject to law means
It's correct.
unless restricted by law. But कौन सा law which exists for the reason कि subsequent legislation के लिए relating to the Supreme Court, there has to be a specific authorization in terms of 55 item 55 जो specific authorization नहीं है सारी constitution में.
That is the precise question, your lordship.
नहीं
have to
मिस्टर
decide.
हसन,
That is
आप हर
what-
चीज पे प्रिसाइज क्वेश्चन वो कह देते हैं, अपना तो आपका जवाब ही कोई नहीं.
जवाब तो
Whoever
आप सुने
says
तो मैं
whatever
आपको
to
दूं।
you, you
मुझे
agree with
बताइए
that. अच्छा नहीं, आप देखिए सवाल आपसे ये है कि I'm just adding to what Justice Ijaz just said. 191 की बड़ी important interpretation का सवाल है हमारे सामने. एक ये सवाल इस तरह भी पढ़ा जा सकता है 191 को, and that's what we want you to assist us with. You see, whether at all 191 envisages that there can be a law made by the parliament that regulates practice and procedure, and once that law is there, then the Supreme Court rules will be subject to that law. So the fact that it is mentioned there that there could be a law relating to practice and procedure makes it an enabling provision. Is that a correct interpretation or not, is a question I'm asking you. Subject to law, constitution and law, is that an enabling provision because the constitution is saying that there could be a law relating to practice and procedure, meaning by that there is a substantive power given to the parliament to make law relating to practice. Is that a correct interpretation? And could we, if we have any problems, could we just tag along entry 58 with it to then make this complete? ये पहला सवाल आपसे पूछेगा, जवाब प्लीज दे दें कि आप ये पढ़ते हैं कि कॉन्स्टिट्यूशन में पावर है कि आप प्रैक्टिस एंड प्रोसीजर के लॉ के लिए लॉ बना सकते हैं, वरना उस लॉ का क्या मतलब है 50 आर्टिकल 191 में.
Redundant हो गया वो law cover.
मैं जवाब दे दूं अगर आप
अब इसका
दीजिए
जवाब
दीजिए, कब से
सर,
मुंतजर
आप
हैं.
सुन- सर अगर आप 191 को आइसोलेशन में पढ़ेंगे तो आपकी बात ठीक है कि लॉ रिस्ट्रिक्ट करते हैं, लेकिन अगर आप 191 को 142 और एंट्री 55 से पढ़ेंगे
पढ़ लें, उससे क्या
के साथ
चलिए,
पढ़ेंगे
ठीक है.
तो उसमें पावर नहीं है.
ठीक है.
तो उसमें पावर नहीं है.
ओके,
आप
चलिए,
या-
ठीक है,
आप
आपका जवाब आ
accept करें
गया.
या reject कर
अगर
दें.
जरा घड़ी देखिए
जी सर.
और टाइम आपका कितना हो गया पूरा.
I am grateful for.
If I may ask you a question.
मैंने तो अभी आर्ग्यू ही नहीं किया, क्वेश्चन ही आंसर कर रहा हूँ.
इसी तरह होता है, don't worry. आर्टिकल 191 में जो ये पावर, ये जो सब्जेक्ट लॉ है, can parliament make a law in exercise of article 191 repealing the Supreme Court rules 98?
No. So that is what.
Let's take it one step.
यही तो सवाल है आपसे कि क्यों नहीं.
अब अगर
आप हर दफा yes कर
सर
देते हैं.
उसमें इबाहम है ना, दैट इज, ये तो आपने इंटरप्रेट करना है.
तो छोड़ दीजिए,
वो
फिर हम
clear
देख
नहीं
लेंगे.
है
फिर
ना.
आप बैठिए, फिर हम कर लेंगे.
कर लेंगे हम interpret.
आपका क्या फायदा?
शुक्रिया.
सर, मैंने तो आप मेरा मेन पॉइंट
अरे चलिए, फिर दूसरे हम उनसे पूछ
I
रहे
have some questions for you. I have some questions for you. So stick around at this rostrum. Now you say that the law that Parliament can make under 191 cannot repeal the Supreme rules made, which are currently the Supreme Court rules 1980.
Absolutely.
Can there be an implied repeal?
They cannot be, sir.
Now, order, for example, to take one example, order 11 of our rules says benches shall be constituted by the Chief Justice. Now, section 2 of this law constitutes a committee of 3 to do the same job. It follows from this that there is an implied repeal of order 11. But your case is that since there can be no repeal, there can't be any implied repeal. So on that basis, potentially we have now a conflict between what section, assuming legislative competence, section 2 and what the Supreme Court rules are saying. Now, how is that to be addressed? How is that to be addressed? If your submission is correct, there can be no repeal, therefore there can be no implied repeal. Yet there is section 2 of the Act. In section 8, they have provided a overriding clause, which effectively is an implied repeal. But you say that can't happen. So if Parliament makes a law like this, and there is a conflict, and here is the conflict, I'm giving you one example of it, how will that be resolved?
So that will be very difficult to resolve, because I would humbly submit that my answer to your question would be that the parliament has got no power to do that. Because parliament, so your function cannot be controlled by the parliament.
Now, if I
That's
may,
against the.
now, if I may, in light of this very interesting debate that has, or discussion that has been going on, so what does subject to law mean? If I may draw your attention to the 1956 Constitution. In that Constitution, the third schedule provided the rule-making power of the Supreme Court. ठीक है? और आप उसका आर्टिकल 177 पढ़ेंगे, है आपके पास किताब?
जी 56 का कॉन्स्टिट्यूशन, ओरिजिनल जुरिस्डिक्शन का रूल मेकिंग का
नहीं, 1956 कॉन्स्टिट्यूशन के थर्ड शेड्यूल में रूल मेकिंग पावर थी सुप्रीम कोर्ट की.
56 कॉन्स्टिट्यूशन दें जी.
अगर मैं इन द मीन टाइम
मैं आपको पढ़ देता हूँ,
जी
ठीक है? उसके that had to be read with Article 177. Now this is very interesting, and my question to you is whether the language as used in Article 177 and the language used in Article 191, is there any difference? 177 of the 56 Constitution said, until other provisions in that behalf are made by Act of Parliament, the provisions of the third schedule shall apply.
Right.
So it seems to me that here was a direct enabling ground. Third schedule said rule-making power is with the Supreme Court and the High Courts, but 177 said until other provision in that behalf, other provisions in that behalf are made by Act of Parliament. Here, the language is not like that at all. And if we regard law as used in 191 to be an enabling power, then that sets up this conflict between, because the law cannot repeal the Supreme Court rules, there can't be an implied repeal. So maybe one possible way of avoiding this conflict is to read law as meaning that it is only it can only apply a break, or let's say it's not an enabling power, because the framers of the Constitution did have Article 177 before them. They could have followed this language. They would have said, until other provisions in that behalf are made by Act of Parliament, Supreme Court may make its rules. They didn't do that. If you are right, and as you say, it is for us to ultimately decide, if the law cannot repeal the Supreme Court rules, if the law cannot impliedly repeal the Supreme Court rules, then where does the conflict go? And maybe if to regard it as not an enabling power allows for the conflict to
Because
disappear.
the rules have the constitutional power. That is also a question, that whether the parliament can undo a thing which has been done exercising the constitutional power. The parliament cannot. That is the
You
answer.
see, in Baz Mohammed Kakar, this court has
उसमें
very
यही बिल्कुल है.
specifically held that because these rules have been framed in exercise of constitutional powers, they cannot be displaced, amended, modified, overruled by ordinary legislation, because these rules stand at a higher pedestal.
This is what I have actually reproduced Baz Mohammed Kakar's citations on that basis.
Yes.
Mr.
Hassan,
Hassan,
I
I
believe
believe
it
it will be last
अब आप
question.
कितना टाइम लेंगे आप बता दीजिए.
मैं पॉइंट्स को सिर्फ आपको
कर
रेफर
लीजिए
कर देता हूँ.
खत्म. हाँ.
सर अमीनुद्दीन साहब
The
का
question
क्वेश्चन.
is whether we were able to frame rules in 1980 in derogation of the existing law at that time.
My lord, my honest answer would be no, if the law would
Then-
have existed.
then
Because
the
this is
rules-
an exercise which has been
The
done.
rules
So
are
perhaps
subject-
one way to look at it would be that if you were to look at your rules in future, but then you would have to see whether the law provides for anything which is within the constitutional
No,
framework or
no,
not.
the
That's a very
question-
important
the-
question
the
which we
second
are
part is
missing out. Because
that if-
here, in fact, one of the other aspect that this committee is doing, it is preventing an access to the Supreme Court directly and preventing the Supreme Court from making
the
an order.
question. This is the question. If the parliament legislates, which is, as per your contention, in contradiction with that rules, it is the basis for striking down of the legislature's legislation.
If it is in conflict with the clear provisions, very simple provisions of the Constitution, it is a reason to strike it down.
If I may follow up on that. You see, the 1980 rules replaced the rules of 1956, the Supreme Court rules 1956. The Supreme Court rules of 1956 were existing law within the meaning of Article 268 when the present Constitution came into force on the 14th of August 1973. That is when the power of, or the jurisdiction, whatever you want to call it, if such jurisdiction exists, of Parliament to make a law came into being under Article 191. So there was no vacuum, there was no break. As soon as that power came into existence, there were already the Supreme Court rules in the field, the ones of 1956. So therefore, there was a continuity perhaps. All that happened was that in 1980, those rules were changed. So if I may ask you my question in a slightly different form, could say in 1974, 1975, 1992, sorry, not 1990, say in 1973 or 1974, 1975, could Parliament have made a law under 191 repealing the Supreme Court rules of 1956?
No. No, absolutely not.
So the same, so the enabling aspect of it,
The fundamental point that
I like your brevity.
Ji?
I said I like your brevity.
Leonard
You
Council,
say yes,
Leonard
no,
Council.
which we really appreciate.
Leonard Council,
Are we
Leonard Council.
concluded?
Leonard
Because I want to
Council.
hear you say something more,
Leonard
if you
Council.
want to say something more.
Leonard Council.
Your Lordship would allow me, I have submitted, I am
Leonard
still
Council.
answering the question, my lord.
Leonard
What
Council.
can I do?
I like your brevity.
Leonard Council. This is a question for you and for all the councils. Can you cite any example from any jurisdiction around the globe that give precedence to rules made by an unelected court over a primary legislation made by a competent forum?
Your Lordship, I would respectfully
think
submit,
this
in
is-
fact, I wanted to make, Your Lordship may rethink and rephrase this.
Answer the question
concept.
again, you're doing this.
Your
I
Lordship,
would respectfully say,
this is not,
so answer the
this is
question.
not an unelected court, because
भाई
this
आप
is a
जवाब दे
court
देना, कहीं दुनिया में
which is-
होता है.
which is
दुनिया
created
में
by the
दुनिया
con-
में पार्लियामेंट के बनाए हुए कानून से बाला कोई रूल्स हो सकते हैं तो वो साइट कर दीजिएगा एग्जांपल.
जी मैं आपको करके उसका जवाब में दे दूंगा, बट जो क्वेश्चन है, रूल्स जो है, दे हैव टू बी विद इन द कॉन्स्टिट्यूशनल फ्रेमवर्क.
चलिए फिर आप दे दीजिएगा, जवाब
जी.
दे दें.
मतलब माय नेक्स्ट पॉइंट,
हसन साहब इसी क्वेश्चन में इसको बढ़ाते हुए, क्या आपके कहने का मतलब जो मैं समझाऊं, आप कहते हैं कि ये रूल्स वंस फ्रेम कैन नॉट बी अल्टर्ड, और अगर ऐसी कोई बात है तो कॉन्स्टिट्यूशन से आप बताएं, क्योंकि हम कॉन्स्टिट्यूशन में डील कर रहे हैं, कि क्या कॉन्स्टिट्यूशन ने कोई बार लगाया कि पार्लियामेंट हैज नो अथॉरिटी टू मेक लॉ व्हिच इज इनकंसिस्टेंट विद द रूल्स फ्रेम्ड बाय द सुप्रीम कोर्ट? ऐसा कोई प्रोविजन कॉन्स्टिट्यूशन में है तो देन ओके, इफ नॉट बता दें क्या ऐसा.
let's put it another way. If there is no bar, there is no permission also, and this is what we are arguing since morning, that there is no permission for the parliament to make the law.
हम वापस उस पे आ जाते हैं.
If there is no specific bar, there is no permission at all. Your Lordship, this is the way to look at the constitution.
हम वापस 199 में आते हैं. ओपनिंग वर्ड्स हैं, the rules must be subject to law and the constitution
And the law, but
इसका
who
मतलब
will make?
rules ताबे हैं
Does
कानून
it-
के, और
does it-
कानून 142 में बताया गया है पार्लियामेंट का काम है to make law.
Lordship, मैंने शुरू में एक
ये
argument
देखिए आप
किया
जरा
था.
आप बात की देखें, वही बात, बुनियादी बात वहीं ठहरती है.
बुनियादी उधर ही है, सर, वो
आप तो
काम।
सुनने तो लेना. वो जो एजाज साहब का सवाल था, देखिए अगर ये कानून में कोई ऐसी चीजें हैं जो कि गैर आईनी हैं तो उनको तो स्ट्राइक डाउन किया जा सकता है. मगर एजाज साहब का सवाल अपनी जगह है, वो आप सवाल वो तो आपने बिल्कुल नजरअंदाज कर दिया कि वो बना सकते हैं रूल्स या नहीं, वो आप हाँ या ना जवाब दे देते
सर
हैं
मैंने
हमें,
तो सर
और
मैंने
बस
जवाब
चलें फिर,
दिया
अगर यही जवाब है तो हम सुन लेंगे।
सर मैंने जवाब तो दिया था उसका आपने
तो आप कह देते हैं ना ना हाँ बस,
सर
फिर
मैंने तो लॉ से
तो
साइड
हम
किया हुआ है
हम आपको आर्टिकुलेट करेंगे
सर
चीजें।
मैंने तो जवाब दिया हुआ है जनाब को, अगर
तो नहीं, फिर अगर नहीं है तो फिर बस जाहिर ना करें, किसी और को मौका दे
जी
दें ना।
मैंने तो सर जवाब दिया हुआ है कि वो
नहीं नहीं,
नहीं
बस
बना
छोड़िए ना,
सकते।
फिर आप रोस्टर में
जी,
अगर आपको कोई वही बातें अगर
मैं
हमसे
बस
एग्री
एक
या
आपको
डिसएग्री
दो
करेंगे,
चीजें और बता देता हूँ सर
जरा जल्दी कर
इसमें।
लें प्लीज।
सर दिस लॉ अफेक्ट्स
वो ब्रेविटी इज द सोल ऑफ विट।
एब्सोल्युटली
जी,
सर, दिस
थैंक यू
इज
फॉर अग्रीइंग।
for a change, I believe. Sir, the Constitution has created a balance between the three
प्लीज,
pillars.
अब ये बात कितनी
Sir,
दफा कर चुके हैं, ट्रिकोटमी ऑफ पावर्स की।
Sir, नहीं,
हाँ,
if that's a different point.
जी
After 18th constitutional amendment, the Chief Justice, जो पुराना concept था, Chief Justice is first among the equals, has gone away because the Constitution has now given a provision in the Constitution where the Honorable Chief Justice has a supremacy or a primacy, at least to the extent of the administrative functions, because the Constitution has provided a provision that the senior most judge would be entitled to become the Chief Justice. And there are other functions in the Constitution which are ascribed or prescribed for the Honorable
ये
Chief
आप
Justice
बिल्कुल,
alone.
you're just waffling, you're not articulating
Sir,
any
sir,
contention.
this is what, so what I am saying
I mean,
is,
it's obvious, it's written there.
उसके
What's so profound here?
उसके कॉन्स्टिट्यूशन के कॉन्सिक्वेंसेस है ना,
Mr.
जिसका
Hassan, we will not permit this.
हर चीज का एक सर मीनिंग है ना, अगर आप उसको देखें तो वो बात आ जाएगी ना कि सुप्रीम कोर्ट के जो फंक्शंस हैं, सुप्रीम कोर्ट के ऑफिस को आप इस तरीके से थ्रू अ सब कॉन्स्टिट्यूशन लेजिस्लेशन नहीं कर
रिपीटिशन है
सकते।
ना, कोई
That is the
मजीद
whole-
बात कर
जी।
लें ना, मजीद कोई पॉइंट कर लें, वही आप बात 6 दफा करेंगे।
So constitution of the benches, जो मैंने the case law is the sole prerogative of the honorable chief justice, और इसमें independence of judiciary के लिए जो एक it's a basic principle of constitution system, मैंने case law आपको दे दिया है। And my last point जो appeal के अंदर मैंने already point out किया था कि appeal 185 के अंदर
देखिए, उस पे आपने बिल्कुल बात नहीं की, और मंसूर शाह साहब ने ये बात की थी। इस कानून में दो चीजें हैं, नाम तो इसका सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर है, मगर एक सब्सटेंटिव राइट भी क्रिएट कर रही है, राइट ऑफ अपील। वो ये दो चीजें अलग अलग हैं, इसका नाम शायद हो सकता था जरा कुछ और, मगर ये सिर्फ प्रैक्टिस एंड प्रोसीजर को नहीं कर रही है, एक सब्सटेंटिव राइट भी क्रिएट कर रही है। उधर उस पे आप कोई अपनी राय देना चाहते हैं?
जी जी सर, उसमें फिर 185 पढ़ लीजिए।
हम नहीं पढ़ेंगे, अपनी राय दीजिए
मैं
ना।
अपनी राय
नहीं
ये है
हसन
कि
साहब,
right of
उसमें
appeal-
उसके लिए अगर आप एंट्री 58 एक सेकंड पढ़ेंगे।
जी सर,
एंट्री 58
सर,
उसमें एक सवाल है आपसे,
जी।
अगर आप जवाब दें। एंट्री 58 जरा पढ़िएगा तो फिर सवाल है।
matters which under the constitution are within the legislative competence of Majlis Shura or relate to the federation.
नहीं 55 sorry
55 जी, 55 है jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental power.
आप इसको कैसे पढ़ते हैं, क्या मानी है इसके?
इनलार्जमेंट है या ये सब वो है, रिट्रैक्शन है?
और खास तौर पे जो टू द एक्सटेंट बाय द कॉन्स्टिट्यूशन अंडर द कॉन्स्टिट्यूशन, इनके क्या माने हैं?
जी मैं आपको बताता हूँ, इसको दोबारा से पढ़ लेते हैं, आप देख।
सवाल तो ये है ना कि इसमें ये देखिए मासूम हसन, सवाल ये है कि ये कॉन्स्टिट्यूशनल अमेंडमेंट इस तरीके से हो सकती है जिस तरह ये की गई है,
सर ये
और उसके जो यहाँ पे रिपोर्ट मांगी गई थी कि वो किन सर्कमस्टांसेस में हुई है, वो रिपोर्ट आई है? अभी तक वो रिपोर्ट ही नहीं आई अभी तक।
सर दैट्स अ डिफरेंट क्वेश्चन। मेरा इसमें मैंने तो आर्ग्यू किया है, वो आप कहें मैंने नहीं आर्ग्यू किया।
मानी
जी आपका
एंट्री
सवाल का
55
जवाब ये
के
है
जरा
कि सर
मानी
एंट्री
बता दें।
55 के अंदर
हाउ यू अंडरस्टैंड एंट्री 55?
Sir, this relates to jurisdiction and powers of all the courts except the Supreme Court with respect to any matters in this list and to such extent as is expressly authorized. So it has to be expressly authorized by or under the Constitution.
क्या माने?
इसका मतलब है कि Constitution उसको authorize स्पेशली करेगा तो वो चीज आएगी।
तो बाय हो गया ना, अंडर द कॉन्स्टिट्यूशन का क्या मतलब?
Sir, which is by or under means
Are you saying there are interchangeable words and under doesn't add anything? Is that what you're saying?
No, sir.
They can take this question with a level of seriousness. Don't just sort of flip-flop the question like that. It's a very important case. You give it the, you just agreeing, disagreeing. My lord has asked a very specific question, and under what does it add? Say nothing, say something, what does it add?
Sir, by or under the constitution means that anything which is either provided by the constitution or under the constitution, which would your lordship deduce through an interpretation.
Are
Could
they
also
interchangeable
be
terms?
included in that.
That
Because
doesn't-
by
it
the
does-
constitution means that has to be included in the constitution.
Whether it is expressly provided in the constitution or by implication provided by the constitution, but there is a question
No,
here.
no, no, no.
You see,
Sir,
enlargement, the
but
word.
it- but it
आप
relates
जवाब तो
to-
देना पहले सवाल।
सर उसका
देखिए आपसे पूछा है ना बाय और अंडर क्या अंडर बाय द पार्लियामेंट है बाय द एक्ट ऑफ द पार्लियामेंट है
No,
अंडर
sir,
द कॉन्स्टिट्यूशन
it
अंडर
doesn't
द
read that.
कॉन्स्टिट्यूशन से क्या मानी कोई रेफरेंस देना।
under the constitution which is provided, and in the constitution would include everything and anything which is in there.
Mr.
which
Hassan,
would
you're
be a
not,
power to make
Hassan
legislation.
साहब, you're not adding anything
Sir,
useful.
मैं बस conclude
फिर आप
अच्छा,
इसको conclude ही
एक चीज
करें।
सिर्फ बता दें, enlargement of jurisdiction. One, enlargement, the word enlargement in itself implies that something already exists and it is
Absolutely.
being enlarged. Now, is providing a fresh appeal is conferring a jurisdiction or enlarging a jurisdiction?
It's conferring the jurisdiction. It's not enlargement. It is not.
Why?
Because it does not exist previously. So
In the
anything which
constitution.
maybe enlargement would be which is already existing and your lordships are given additional powers to do that, or.
Can you cite an example?
Learned
Cite an example.
Learned counsel, ये अपील जो है, ये अपील किस jurisdiction और power की remedy है?
Sorry?
किस power और jurisdiction की remedy है? The appeal 184(3) की है. That power already exists. And it's only a continuation of the same power.
Sir, 185 के अंदर 184 की appeal does not exist with utmost respect.
Learned counsel, जो my lord ने सवाल पूछा
वो
है,
सवाल के ऊपर
कि
again
देखिए ना,
देखिए
दो-
question
सुन ले,
ये है
सवाल
कि
ये
if
है,
your lordships are to
सवाल ये
read
है,
into the
सुन ले,
constitution, then that's a
Counsel,
different question.
The question is 184 is before 185. ठीक है? सारी जो अपील्स सुप्रीम कोर्ट के में प्रोवाइडेड हैं वो हर उसकी तमाम सूरतें 185 में मेंशन की गई. If the framers of the constitution wished to provide an appeal under 184, they could have easily added something in 185, 185 के अंडर 184 के ऑर्डर्स के अगेंस्ट अपील हो सकती है. आर्टिकल आइटम 55 में enlargement का यूज वर्ड इस्तेमाल करके ये कहना कि जी हम एक नई jurisdiction create या confer कर सकते हैं, is that doable?
और उसी में मैं ऐड कर दूं कि कंपटीशन कमीशन एक्ट में अगर अपील है और काफी कवानीन है जिसमें सुप्रीम कोर्ट में अपील आ गई है तो फिर वो तो एक्सप्रेसली कॉन्स्टिट्यूशन में नहीं दी हुई जुरिस्डिक्शन लार्ज
सर
वो कैसे फिर अपील आ गई?
We are trying to mix the two things. That is by virtue of another entry in the constitution, the legislation relating to that has got nothing to do with 184 power.
जी मैं वही आपसे पूछ रहा हूं एंट्री 55 में स्पेसिफिकली enlargement of jurisdiction डील करती है तो we will not go to any general entry, we'll go to the specific entry first which says that enlargement of jurisdiction can be either expressly given in the constitution और अंडर तो का मतलब ही नहीं अभी तक आपसे आया, लेकिन चले बाय द कॉन्स्टिट्यूशन एक्सप्रेसली तो फिर कंपटीशन कमीशन की अपील कैसे आ गई?
सर उसमें जो अपील
एक्सप्रेसली
जी सर 185 को जब आप पढ़ेंगे 185 के अंदर अपील
तो मैं कंपटीशन कमीशन के
Really, Hassan
sir,
Saab, you're not
sir,
really
sir,
answering
मैं एक
anything.
जवाब देता
No,
हूं.
no, you are not answering. Sorry to say. तो आप
Sir,
किसी और को देते ना,
sir,
अब
I
काफी हो गया ना, अब देखते हैं 1 बज रहा है. अब आप कितना आपने आधा घंटा 20 मिनट आधा
जी,
घंटा
जी,
कहा
जी,
था, हमने
मेरा-
आपको
मेरा
2
सर
घंटे दे
conclude
दिए.
सर
मैं एक मिसाल देता हूँ आपको. आप एग्जाम्पल की बात हो रही है. देखिए मैं लास्ट डेट पे भी मैंने एक क्वेश्चन किया, उसका जवाब नहीं आया. इसे आपके लॉ रिफॉर्म्स ऑर्डिनेंस 1972 के तहत एक कॉन्स्टिट्यूशनल प्रोविजन जो 199 है उसके लिए एक अपील प्रोवाइड की गई है. उस अपील को बाद में 269 आर्टिकल 269 में उस जो आपके ऑर्डिनेंस था, मार्शल लॉ ऑर्डिनेंस, उसको कॉन्स्टिट्यूशनल कवर दिया गया कि ये जो ऑर्डिनेंस के तहत एक अपील की रेमेडी दी गई है वो दुरुस्त दी गई, वो भी कॉन्स्टिट्यूशन, वो कि वो हाई कोर्ट से मुतालिक है, नो डाउट, लेकिन हाई कोर्ट को भी 202 कंट्रोल कर रहा है, सुप्रीम कोर्ट को 191 कर रहे हैं, दोनों सेम लैंग्वेज है। अगर 199 में अपील की रेमेडी आज तक चली आ रही है, क्यों ना 184(3) में आप कैसे कह सकते हैं कि ये नहीं होनी चाहिए? वहां होनी चाहिए बेशक हाई कोर्ट से।
फिर वो सिविल प्रोसीजर कोड की अमेंडमेंट के थ्रू अपील है, दैट इज अ डिफरेंट
वो
connotation.
non-conformance ordinance
Here
है
it's a
वो।
constitutional
See,
provision, it's a
non-conformance
different
ordinance
connotation.
और-
वो तो हम उसको दो चीजों को इंटरलिंक नहीं कर
और
सकते।
आइटम 55 में हाई कोर्ट के मुतालिक लेजिस्लेशन पे कदगन नहीं है।
कोई भी नहीं है।
Yes,
तो-
Mr.
दूसरा
Bhandhari,
आपसे पूछा था
I think
enlargement.
you want to
I
now
still
take
have
the
a
rostrum.
question. I have a question. I have a
एक
question. ये जो
सवाल
आपसे enlargement of jurisdiction पूछा था, I go back to the question कि जो constitution of benches है, वो कौन सी jurisdiction है under the constitution जिसको enlarge किया जा रहा है?
कोई भी नहीं है। वो तो आपने कॉन्स्टिट्यूशन ऑफ बेंचेस तो रूल्स में बनाई है, कॉन्स्टिट्यूशन में तो कोई प्रोविजन नहीं है। दैट्स इज द
So
होल
that's not an enlargement of jurisdiction, or is it a jurisdiction?
that is all. In fact, that is a jurisdiction. That's not an enlargement of jurisdiction.
Mr. Hassan,
Constitution of benches are by way of the rule making part that the court has decided के benches इस form में
So that's
होंगे।
not an
England
exercise
के-
of jurisdiction?
England के अंदर they have actually formed a special law for that.
कि ऐसी जबानी बात ना करें, लॉ का हवाला दीजिए।
सर
इंग्लैंड में ऐसे लॉ हो गया, ऐसे
ये है
नहीं
कि
करें
law-
ना, दें चीजें हमें फिर।
मिस्टर हसन, इस लॉ में दो चीजें हो रही है ना, एक प्रैक्टिस एंड प्रोसीजर है, एक अपील की जुरिस्डिक्शन की बात है, तो दो मुख्तलिफ चीजें हैं, इसको सेपरेट रखें।
बिल्कुल सेपरेट करें।
खालिद बंधारी साहब शायद बेहतर जवाब दें, शायद या सुनते हैं इनको।
जी सर, बिल्कुल। थैंक यू वेरी मच फॉर
Thank you. You are a petitioner?
My lord, I am representing PTI. Your lordship said.
Are you a petition number?
My lord, notice was issued in all petitions.
Have you filed something?
My lord, I filed two concise statements, CMA 3933
3933
and CMA number 8351.
8351. What are the difference between the two?
My lord, the first was filed several months ago. The 8351 was filed yesterday in the light of the observations that have been made on the last date of hearing, the submissions made by council. I've tried to address some of the points that have come up during your lordship's observations.
No, first of all,
today.
tell me where you stand.
My lord, I am under instructions to support the petitioners, but with some caveats. I am not saying, and I'll just say this and then move on to my submissions. Well, I am not saying that the parliament cannot per se make any law as far as the practice and procedure of the Supreme Court is concerned. It can, but that power is heavily circumscribed by various express and structural limitations within the Constitution. So that's heavily circumscribed. But within those limits, it can, and I'll expand on that. So, as my Lord Justice Mansoor just said, there are two aspects to the.
First, finish your thing.
My Lord.
Then you come to what we have
My
observed.
Lord, yes.
You said you are conceding that the parliament can, but their powers heavily circumscribed.
Heavily circumscribed.
Now, which particular provisions of this act are you think the parliament has exceeded its jurisdiction?
If I may, if you could first expound on your initial proposition. Sorry, as far as the first point, if you could expound on that particular part, that the legislature has the power. Please explain that. Then move on to the issue where the restrictions are.
My Lord, absolutely. That's exactly how I will address. And I will address both aspects of the law on this point. First aspect is the practice and procedure aspect, sections 2, 3, 4, 6, 7. And then there is the appeal, and I'll address them separately. I'll start with the practice and procedure bit first. My Lord, the various articles have been read out before the court many times. My Lord, Article 1, let's start off with where the parliament draws its legislative power from. There are two sources in the Constitution. which confer specific power on the parliament to make laws on identified specific subjects. These are the two sources. Now, the question before your lordship and your ladyship, the question before the court is, as has come out in discussion recently, is whether Article 191 by itself, and I emphasize upon the word, my lord, by itself, is a source of legislative power. And my submission on that is that it is wrong. And I'll explain the reasons why I say that. Well, your lordship has already seen the preamble to the preamble itself identifies the source of legislative power that the parliament has invoked. It has invoked two sections, two articles, Article 175(2) and Article 191(2). My lord, let's just read both of them very quickly and then compare their language to Article 142. Article 175, clause 2 says this: no court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by or under any law. This is similar to, but slightly more specific than 191. 191 says, subject to this constitutional law, the Supreme Court may make rules regulating the practice and procedure of the court. Now your lordship may turn to 142. 142 is cast in different language altogether. It starts off by saying, subject to the Constitution, a Majlis-e-Shura Parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. So the legislative power is conferred with respect to identified subjects, subject to the Constitution, and the appropriate legislature is identified. So that's how, in my humble opinion, you identify whether an article is a source of legislative power. It identifies the subject on which the legislature can enact law, and it identifies the legislature itself. Now, if your lordships go back to 175(2), it simply says, no court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by any law. It doesn't say what is the...
Clarify for me. You are saying Parliament does not have power to legislate except items mentioned in the federal legislative list. Is this what you're saying?
My lord, in the what is mentioned in the federal legislative
Yes or
list,
no?
Yes, and also on what is mentioned in the body of the Constitution. And I'll just take your
Okay, now
lordship.
I will give you an example. My reading of the fourth schedule, I mean, science is developing, artificial intelligence has evolved. Urdu में इसको शायद मसनूई ज़हानत कह लें, outer space, खलाई बसीत कह लें शायद, social media, समाजी राब्ता कह लें, तो इनके मुतालिक पार्लियामान कानून नहीं बना सकती है क्योंकि इन तीनों चीज़ों में से एक का भी जिक्र फेडरल लेजिस्लेटिव लिस्ट में भी नहीं है और आइन की किसी शिक में एक्सप्रेसली या इम्प्लाइडली भी नहीं है। अब जब आप अटेंड कर लें मेरे सवाल को।
My lord, मेरे ख्याल में बना सकती है।
तो आपने अपने ही सवाल को तोड़ दिया फिर अपने जवाब को।
No, my lord, मैं आपने जो लेजिस्लेटिव लिस्ट में एंट्रीज हैं उनको टू द मैक्सिमम पॉसिबल एक्सटेंट,
मैं आपको मैंने 3 एग्जांपल दे दी ना, इनको किसी तरह से भी वहां नहीं फिट हो रही हैं और ना आइन की किसी और शिक में आ रही हैं ये बातें जो मैंने आपसे जिक्र की हैं। तो फिर पार्लियामान के पास तो इख्तियार नहीं है ना, पाकिस्तान स्पेस प्रोग्राम नहीं शुरू कर सकेगा क्योंकि फेडरल लेजिस्लेटिव लिस्ट में इसका तस्करा नहीं है। या तो आप ये आर्ग्यूमेंट करेंगे कि नहीं सिंध कर सकता है, वफाक नहीं कर सकता है क्योंकि बाकी सारे इख्तियारात फिर सूबों के पास हैं।
That's not
ये तो आप जवाब दे देना।
मैं दे देता हूँ।
ऐसे ब्रॉड आप अगर पेंट ब्रश स्ट्रोक्स लगाएंगे तो उसके लिए अपनी मुश्किलात भी खड़ी हो जाती हैं।
Let me explain. For example, with respect to space programs, if Pakistan has entered international
हम
treaties, then
कानून
there
की
are
बात कर रहे हैं,
then
कानून
there
और
are
आइन की।
specific entries which
नहीं,
allow parliament
मेरा बाप
to enact law for implementing international
कौन सा
treaties.
एंट्री है बता दें।
Well, entry 3.
हाँ।
Entry 3, external affairs, implementation of treaties. For example,
आप नहीं आते, आप इसको सुन तो लीजिए ना, ऐसे ना करें ना, थोड़ा सा थोड़ी सी हमारी भी कदर कर लें। एंट्री 3 को ट्रीटीज की तो मैंने बात ही नहीं आपसे की। आप सुन ना, आप सुन भी लेना, ट्रीटी की मैंने बात ही नहीं की। मैं तो आपको कह रहा हूँ पाकिस्तान चले ट्रीटी से खिलाफ ही कर रहा है काम। ट्रीटीज में क्यों जोड़ रहे हैं हम? भाई किसी को आउटर स्पेस से प्रोग्राम करना है, इंडिया ने क्या कोई ट्रीटी के जरिए कर रही है? अगर हम कल शुरू करना चाहें तो आपके मुताबिक हम नहीं कर सकते हैं, या कर सकते हैं तो अगर कर सकते हैं तो वो कौन सा पावर पार्लियामान इस्तेमाल करेगा?
लेजिस्लेटिव एंट्रीज में बहुत सी
बता देना मुझे एक।
फॉर एग्जांपल जैसे ये अगर इसमें ये न्यूक्लियर एनर्जी का
न्यूक्लियर की बात अलग है।
उसके अंदर मतलब आपने मकलक वर्सेस मेरीलैंड का केस
फिर आप लोग इतने मुतासिर हो गए हैं अमेरिकन, हम आपसे आप हमारा रिटर्न आइन है उसकी हम बात कर रहे हैं, उनका आइन अपनी जगह है।
मैं आपकी जजमेंट जो कि आपने
भाई अब जजमेंट को छोड़ दीजिए ना,
सिविल एविएशन अथॉरिटी के केस में दी, उसमें आपने
आप जरा तसल्ली से बहस करें ना।
बिल्कुल,
या तो आप ये आर्गुमेंट पेश ना करें, जब आप ये पेश करते हैं ये बहस सामने या एक मफरूजा करते हैं कि इट इज एज गिवन, तो मैं ये नहीं मानता हूँ। या तो क्या मैं ये वापस लेता हूँ ये बात को। आप कहते हैं कि पार्लियामान सिर्फ वो काम कर सकती है जो 142 फेडरल लेजिस्लेटिव लिस्ट या एक्सप्रेसली या इम्प्लाइडली हो, उसके अलावा कुछ नहीं कर सकती। या तो कहीं मैं इस बात को वापस लेता हूँ। अगर आप इस बात खड़े हुए हैं तो मेरे सवाल का जवाब दीजिए। आप जवाब नहीं देते हैं, आप कहते हैं मैरीलैंड वर्सेस उसमें देख लें, उसको कम क्यों देखें?
मैं स्पेस टेक्नोलॉजी के बारे में तो केस तैयार करके नहीं आया जी, मैं तो प्रैक्टिस एंड प्रोसीजर पे हूं, उस पे मैं सवाल
उस पे बात करें ना। फिर आप ये ब्रॉड स्ट्रोक्स ना पेंट कीजिए।
स्टार्टिंग पॉइंट तो मैं आपसे कहीं से
आप ब्रॉड स्ट्रोक्स जब पेंट करते हैं अपने लिए मसले खड़े कर देते हैं, तो आप फोकस्ड रहें इसी बात पे।
मैं तो 142 जी
लर्नड काउंसिल आप आइटम 58 देखेंगे
जी,
आइटम
58
और दूसरा मुझे सिर्फ ये बता दीजिएगा,
Part 2 entry 3 तो देखें।
notwithstanding आर्टिकल 191, आपका आर्ग्यूमेंट ये है कि the parliament is bereft of jurisdiction legislate in the context of any of the fundamental rights or access to justice.
My lord, I have articulated my argument as yet.
अगर आप कर लें, I think बेहतर होगा अगर आप
you argue as you want. Argue as you want. Please go back to your. I apologize. You argue as you want. चलिए
My lord, for 2 days I have heard all of questions.
करिए.
Let me address those questions.
Yes,
what I'm saying. My lord, I will answer your lordship's question also.
अब आप कर लीजिए ना।
My lord, the starting point for legislative competence is entry article 142 or the body of the constitution. Now, body of the constitution for our present purposes, the only article relevant is article 191. In the legislative list, there is entry 55. Now, these are the two provisions that have to be interpreted and read. Article, as I read, article 175(2), the expression subject to law, which is used in 191, is used in various other articles also. That by itself does not confer any legislative power or on any identified legislature. Just kindly look at Article 14. Article 14. 1.4.
Dignity of man.
Dignity of man.
Article 14.
It says, the dignity of man and subject to law, the privacy of whom shall be inviolable. This by itself doesn't say who will make the law. The province will make the law or the federation will make the law. In order to determine who can make the law for the purposes of Article 14, you have to go to other provisions of the Constitution. The same is with respect my submission for Article 191 also.
ये आर्ग्यूमेंट आप पूरा तो कर लें, तो प्राइवेसी के मुतालिक कौन बना सकता है कानून?
मतलब फेडरेशन भी बना सकती है और प्रोविंस भी बना सकता है, दोनों बना सकते हैं। उनके लिए आपको देखना पड़ेगा कि लेजिस्लेटिव पावर स्प्रेड कैसे है। और दोनों ने बनाए हुए हैं, क्योंकि क्रिमिनल लॉ, पीनल लॉ पे
हो
प्रोविंस भी
सकता है
बना
गलत
सकता है।
बनाए हों।
जी, प्रोविंस भी बना सकता है, और प्राइवेसी वगैरह के बारे में फॉर एग्जांपल इलेक्ट्रॉनिक क्राइम एक्ट है, फेडरेशन ने भी बनाया हुआ है।
नहीं, पर उसी तरह अगर चलें तो 191 में सब्जेक्ट टू लॉ है, एंड सपोज देयर इज नो, एंड आई थिंक देयर इजंट एनी कॉरेस्पॉन्डिंग एंट्री रिलेटिंग टू प्रैक्टिस एंड प्रोसीजर,
There is no.
so then the word law would become redundant in 191.
No, my lord.
How,
No,
what would it,
no,
what would
no.
happen to that?
That's exactly what I'm saying. I'm trying to proceed step by step. So 191, as I read it, my lord, but the mere fact that the expression subject to law is used does not confer any legislative power, just as that it doesn't confer any legislative power under Article 14. What it is, my lord, the power is conferred on the Supreme Court. The power is on the Supreme Court to make rules. Subject to law is a limitation on that. It's a limitation on the power that has been granted to the Supreme Court. My lord, there are two Supreme Court judgments which say that, my lord, your lordship, I've mentioned them in my, in my written submission.
Mr. Bhandhari,
Just
do
cite
you mean that,
judgment cite kar dein.
the
Bring up
first,
the citation.
Mr. Bhandari, do you mean that before making rules, there must be some law?
Well, I'm not saying that. There may be,
So subject to law, what does it mean, subject to law?
my lord, and a validly enacted law by the appropriate legislature. It could be pre-existing, it could
Without any enactment, rule cannot be made.
no, rules can be made. They can
But
be,
subject to law.
my lord, the rule making power is a standalone independent power on the Supreme Court.
But subject to law.
If there is a law, then the Parliament can make that law within the limits that I will just explain.
You said Parliament can make a law.
Parliament can, but I will just explain what in my humble understanding are the limits on that. I will explain that.
Pehle
But
wo
there,
citations de
Ji, my lord,
Mr. Bhandari, that is subject to
citation
constitution
to
and
le
law.
lene.
So you borrowed this power from the constitution and subsequently you made rules.
yes, my lord,
This is the intent.
this is the intent. This is the intent. My lord,
Citation,
the citation is by Muhammad Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My lord, this expression, subject to constitution and law, was discussed in detail by Mr. Justice Cakehouse in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739,
एक सेकंड दूसरा कौन सा है?
देखने तो दें,
2015 SCMR
अब तो दो यार।
हाँ,
1739.
ठीक है, ये
The
phrase
LDA
discussed
versus
हुआ है.
Imrana Tivana.
This phrase has been discussed.
This phrase, subject to the constitution and the law,
कैसे, किस नतीजे पे पहुंचे?
and they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the constitution.
ठीक.
See, so that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the constitution.
रेलेवेंट पेज बता दीजिए उसका कौन सा जजमेंट है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले का?
And Imrana Tivana ka hai ji 2015 SCMR 1739, paras 51 to 53 at 1764, 1765.
लॉ डेवलपमेंट अथॉरिटी वो टिवाना
इस वाली लॉ की सोर्स पर क्या, गो
जी,
अहेड.
iski. So this by itself, I say. So you go back to 142, and there is no other provision in the body of the constitution dealing with this. So my lord, you go back to 142. 142 takes you to entry 55. So let us see whether there is any
Entry 55 is only related to the jurisdiction part.
My lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the constitution.
My lord, what?
ये जो आप अभी बता रहे हैं ना, इसमें तो सब्जेक्ट टू द
my lord,
कॉन्स्टिट्यूशन है
it's-
एंड लॉ के ऊपर नहीं है, इसके ऊपर आप जो डेफिनेशन बता रहे हैं
Cakehouse साहब ने specifically subject to constitution and law भी discuss किया.
जजमेंट है ना, ये एलडीए का जो जजमेंट है इमरान टिवाना का,
नहीं सर, आप Cakehouse वाला देखिए. Cakehouse साहब की.
52 the only word subject to the constitution.
No, sir. ये जो 65 सुप्रीम कोर्ट है, उसमें दोनों
Then
डिस्कस
it is you referring the article 142, उसमें तो शब्द लफ्ज़ ही शुरू में
वो तो
introductory है,
सब्जेक्ट
तो बताया subject to constitution.
जी, बट जो 65 सुप्रीम कोर्ट है उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया है।
इसका जो 65 का कौन सा पेज?
623 at 633
जरा इसको पढ़ ले।
65 अगर आप देखें सर
यस
जी माय लॉर्ड एट 633
ये भी subject to this constitution ही है, law नहीं है इसके अंदर.
तो है जी आप देख लें
पेज आप बता रहे हैं उसके तो नहीं मिल रहा
जी
है.
जी ये आप यहाँ से
You are referring
पढ़
page
देना।
633.
ये सर मैं नीचे से 11th 12th line from the bottom
पढ़िए
at 633 the central legislature can legislate with respect to jurisdiction of courts but the jurisdiction granted by article 98 is subject only to this constitution and not to this constitution and the law a reference to
तो
the
ये तो
various provisions of
then my lord is correct.
my lord आगे देख लेते हैं
अजी अच्छा
a reference to the various provisions of the constitution will show that whenever it uses only the word subject to this constitution, it does not mean subject to this constitution and the law. But whenever the intention is that a particular provision should be subject not only to the constitution, but to a law enacted by virtue of powers granted by the constitution says so. So when constitution and the law.
So what? I'm not following.
Well, what it is
नहीं,
saying is.
वो जो आपकी don't use your own words, use the words of the
Well,
judgment.
this is that whenever the intention is that a particular provision should be subject not only to the constitution but to a law enacted by virtue of powers granted by the constitution.
It's not
begs the
enabling, it's
question.
not a power that is giving legislative competence.
Yes, that's what I'm saying, that
You have to go
then
back looking for the competence.
yes, you have to go to the source of the power in the constitution, and
This
there
is-
the
this
source
is-
of the power
this is-
has to be in some other provision of the constitution, which takes you to 142, and 142 takes you to
No,
entry
fair enough,
55.
but that's not coming out of this judgment.
Well, that is the only judgment on this that I
No, but this.
ठीक है आपने मेहनत की, that's good.
Well, but this is how I read this.
Sure,
passage.
sure.
Well, then let's go to entry
And
55.
you say that that law under 191 would stand through 55,
It can only stand through 55.
only through.
Only through
Chale.
55. Your
पर
lordship has-
एक सेकंड ठहर जाइए.
Well,
Why not 55 read with 59?
but these are 59.
No, the 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा my understanding is I may be subject to correction. It may not specifically be mentioned there, but it can expand. If otherwise 59 is redundant, so then ancillary matters, incidental or ancillary matters can be added on to. So every provision, every item should be read with 59.
Absolutely.
ठीक है. अच्छा,
Absolutely.
एक second. Incidentally, you mentioned privacy, and I was just going through the list. I don't come across that word in the fourth schedule. Please correct me if I'm wrong.
Well,
You said the federation can make law. You started with Article 14 and privacy you mentioned,
my lord.
but the cursory examination of the fourth schedule does not throw up the word privacy.
It doesn't, my lord, but there
No,
are,
but you said then both the federation can make laws.
and it has.
No, it has. Can it still be unconstitutional?
Well-
But in the argument, you should forget if it has. This they have also made a law, so that's neither is here nor there. But if the word is not mentioned, then your argument should have been that only the province can make the law.
Well, if
Please enlighten me.
my lord, the parliament has, for example,
ये example यही ले लेना.
legislative competence to enact laws about companies. Now, in exercise about companies.
No,
every 30 my lord,
Bhandhari sir, no, please don't do this.
let me-
You, no, don't
at
do this.
least make an argument.
No, you use the word, you chose the word of all the thousands of words circulating in the universe, privacy. You chose Article 14. Either you take back that argument or entrench that argument in legal argument.
That's what I'm trying to do.
आप companies पे चले गए.
मैं कंपनी से एग्जांपल आपको समझाऊंगा जी.
Learned counsel,
कंपनी मैं let me
इसको
answer
मैं जरा
let me
formulate-
answer this question.
इसको फॉर्मुलेट कर दो. आपने जिस तरह कहा कि कानून बनाने का इख्तियार है Article
उसका तो
14,
जिक्र है इसमें।
regardless
इसका तो
of
जिक्र
and
है,
notwithstanding
ये
Article
तो
191,
इसका
say
तो
a
remember
law
correct,
is
इसमें है
validly
कि
and
cooperation
competently made
31 है,
by the legislature.
तो है specifically.
What if that law is in conflict with the rules made by the Supreme Court under Article 199, 191? How will you read subject to law? Will the rules prevail or that law?
I will come to that, but let me answer my Lord the Chief Justice's question. My Lord, in exercise of power granted by entry 31, the company law is there. Now, the company law contains elaborate provisions which deal with the question of privacy of businesses, their premises. It deals with when search and seizure can be made, if documents can be.
Take the point.
So, similarly, because criminal law is on the concurrent list under entry
We
one.
make the
Article
point about
142.
privacy.
Therefore, province has also made laws which affect the concept of
Bhandhari
privacy.
Sahab,
Well, privacy alone, privacy can very well be a standalone subject matter of a statute. It is a concept
यही तो
which
पूछ
can
रहे हैं federal or provincial.
both. It
Okay,
can,
Okay,
You
ठीक
made
है.
your,
can
you
be
made
both.
your point. If you
It
could
can-
come back to
it
the,
can be both.
you made your point.
My lord.
We've noted your
My
point.
lord.
If you
I
could come back to entry 55.
Entry 55. Let's read it, my lord. Jurisdiction, and it has two parts. The first part, and my lord, what the Honorable Chief Justice said about entry 59 is exactly my case, and I'll explain why. The first part of entry 55, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. So this doesn't apply to the Supreme Court. And to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and conferring thereon of supplemental powers. Once this is invoked, then, as my Lord the Chief Justice said, matters ancillary or incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution.
But you're missing out the earlier words, as is expressly authorized by or under the Constitution.
Yes.
No, just wait a minute.
My lord.
Where is 184.3 expressly authorized?
It is not.
It is. 184.3 is in the Constitution.
But there is.
समझिए ना, you're not hearing the point. देखिए, extent as is expressly authorized by or under the Constitution. 184 part तो हमें दिया हुआ है ना आइन ने, हमें बस खुद से तो नहीं आया ना, दिया हुआ है आइन ने, ठीक है? The enlargement of the jurisdiction of the Supreme Court. Now the question is that 184.3 power that is already given to us. The Constitution could have not given that power to us. It is not an inherent power of the nature as under Section 9 of the Civil Procedure Code. Correct?
My lord.
It's an extraordinary power, which is rarely given in any constitution in the world.
Correct, man.
Correct? So
Correct.
far, we are good.
Correct.
So that power was given by the Constitution to us. Now, are they giving an appellate forum therein, enlarging the power or taking away the power?
My lord, twofold answer. They are taking away the power.
How?
By, and I rely on the judgment.
तो judgments को छोड़िए ना, आप arguments दीजिए ना अपने.
मैं arguments precedent की base पे दूंगा.
आप अपने हम no contention note कर लेंगे आपके.
My lord, it is a curtailment of power because the concept of finality that attaches to judgments under Article 184(3)
That's a different
is taken
concept.
away.
देखिए, for instance, a three-member bench decides something. Naturally, a three-member bench cannot undo it. Five-member bench हो गई या whatever, full court हो गया. तो 184(3) की उन्होंने enlarge कर दिया power. ठीक है? I'm trying to wrap my head around the fact that you keep saying it's taking away the power. The first power was conferred by Parliament through the Constitution. That power is being enlarged. If this power was given to, for instance, the Senate of Pakistan, you will sit in appeal over 184(3) because Supreme Court can't sit in appeal over its own orders. So then maybe, yes, you're absolutely correct. But this power, it has not gone out of this building. It remains within the building. And unless you say two minds are always better than five, that ends the story. Bas, matlab, so you're saying that more minds would actually be destructive of the 184 inherent power if they think about something, or with the passage of time, they may want to revisit things or maybe want to appeal things. I mean, no. One thing is, of course, you can revisit something. ठीक है, वो तो एक अलग बात हो जाती है, वो तो revisit आप करते रहें, फिर वो देखें number of the judges count होगा, ये होगा, वगैरह होगा. बट ये तो एक स्पेसिफिक पावर दे रहा है. इसमें मुझे समझ नहीं आ रही है, मेरे पावर क्या सुप्रीम, मेरे तो पावर्स कम हो रहे हैं, सुप्रीम कोर्ट के पावर्स बढ़ रहे हैं, तो इसमें आप कैसे कह रहे हैं कि कम हो रहे हैं, ये जरा समझाइए मुझे.
My lord, as I said, I am as a counsel of this court bound by the law that your lordships lay down in precedence.
No,
My
sorry to say, this is, आप मुझे कोई चीज बता दें, you as a council are first and foremost bound by the constitution of Pakistan and the laws of Pakistan. फिर उसके बाद president आएगा. President आप लोग सब पहले रख देते हैं आइन और उसको छोड़ दीजिए, वो बाद में आता है. पहले आएगा आइन, फिर आएगा law, फिर आएगा president. ठीक है? Supreme courts, if they've been making laws, I think that's wrong. Their power is to interpret law. If a law violates some constitutional provision, strike it down. Now, we cannot assume power. I have not taken an oath to uphold the judgments of the Supreme Court. I've taken an oath to uphold the constitution and the law of Pakistan until such time that law, I feel, is violative of a fundamental right or whatever you want to argue, even the whole scheme of legislative scheme that has been laid out. I'm not bound by precedents. If that was the case, I would not have taken oath even as a judge. If I'm bound by all the precedents of the Supreme Court, even dissent, even if the whole court says, I can still maintain I don't agree, but it will still be binding on me. That's a different thing. 189 says it will still be binding on me, but I can say I disagree. Otherwise, you kill dissent also. Then everybody has to agree to everything else. So don't just, these are important questions. You're just sort of saying that your powers have been taken away. I don't feel they've been taken away.
Before you,
My lord, if I
can
can
you
explain,
if you could explain the entry 55 again, I haven't got it.
My lord,
General उसमें बता दें.
my lord, entry 55 allows, number one, only the enlargement of jurisdiction of the Supreme Court.
जी.
And only where there is express authorization to that effect in the constitution, by the constitution or under the constitution. These are the three conditions.
Enlargement का क्या मतलब है? How do you understand enlargement?
Enlargement, for me, as a matter of plain English, means something exists and you make it bigger. As again, my lord, with all
Doesn't it destroy your argument?
my lord, let me articulate.
Correct.
The word enlargement, what enlargement means in the context of entry 55, and what enlargement means in the context of entry 55 has been interpreted by this honorable court.
Learned Council, जरा मेरे समझने के लिए, there can be two situations. One, 184(3) ना होता और सिर्फ एक अपील दे दी जाती. Now here, 184(3) jurisdiction already exists. A remedy is being provided. So there's a distinction between these two situations. The jurisdiction already exists.
My lord, I'll come to that.
An appeal is a substantive right. It has to be substantively given by a substantive provision in the act or the constitution. You cannot by implication or by rules or by subordinate legislation create a right. 184(3) is a jurisdiction in itself, the original jurisdiction. For 50 years, it has existed as such. Why do you think even the dictators or even the legislative assemblies which amended the constitution did not legislate on the one hand or amend the constitution on the other, and why has it all of a sudden now been done? Under what circumstances?
Yeah, Learned Council, Learned Council, I think there's a
Mr. Bhandhari, you are in a very unenviable position.
Learned Council.
I sympathize with you. I sympathize.
I can assure that many of your lordship's questions might be answered, and I can't say will be answered, only if I'm allowed to articulate myself. I can assure, my lord, if your lordship will just allow me to articulate my submissions.
बहुत अच्छा इन्होंने रेज किया है, I think that is also to be seen in historical context. There were only two judgments of this court after this constitution was promulgated, Darshan Mercy case and Benazir Bhutto's case. Regrettably, this court, after 2010, departed from both those judgments. And the manner in which 184.3 in many cases was used, that probably is one reason why the parliament, a representative body, wanted or intended to have these remedies.
My lord,
If you can go back to entry 55, please.
I'll go back to entry
And
55,
Mr.
but just
Mr.
as a brief riposte to that, my
Thank-
lord, two wrongs don't make a right. If this court was wrong, then the parliament is wrong now, and two wrongs will not make a right. And I'll come back to that. My lord, I'll come back to that. Let me go back to
So,
entry 55.
so going back to entry 55,
Well
can I be your voice on the bench
My
and
lord,
help
I'll
you?
be so grateful.
So what
I'll
you're
be
trying
so
to say is just to support you and so that nobody sort of, so what you're trying to say is that entry 55 says that there has to be express authorization from within the constitution for enlargement of jurisdiction. And one prime example is, just as Asha had asked the question, prime example is 185.3, which says specifically that you can enlarge the monetary jurisdiction of the Supreme Court. So that is the express provision
Yes.
mentioned. Isn't that the case?
My lord,
So my question then is that if this is what you're saying that it is purely there has to be express provision in the Constitution, even though I don't understand the under the Constitution. But anyway, let's stick to the by the Constitution. And example would be 185, and perhaps there are some other provisions which would give that express.
I'll come to that.
But my problem with this is that when we talk about enhancement of jurisdiction, I see that, but I have a problem with the practice and procedure part. That practice and procedure doesn't really flow out of 55. And that kind of makes the word law then redundant in 191, because that law is not finding any support. Even if we say 191 is not enabling provision, then that law must stand alone, must draw some power from some competence from some source. It's not coming out of 55 because it is purely for enlargement of jurisdiction.
well, it will come if 55 is rightly invoked, then practice and procedure will come in through entry 59. That, my lord, the Chief
No,
Justice.
but 59 reads that it has to be read along with the substantive part
Yes.
of it, which is enhancement of jurisdiction.
Yes.
So enhancement of
Let me give
jurisdiction is
you-
related.
my lord, let me give. There are, to my humble knowledge, there used to be one very clear provision was Zain Wali Constitution regarding enlargement of jurisdiction, and which was actually taken notice of by this court in Baz Muhammad Kakar's case. This was, my lord, before its repeal, this was Article 247, Clause 7.
नहीं, इसका
of the
पेज
Constitution.
970 पे पढ़िए ना जरा,
जी।
ये पैराग्राफ पढ़ दीजिए, इसमें बहुत सारी चीजें बाज मोहम्मद काकड़ वाले केस के अंदर हैं
जी।
पेज 970 पे पढ़िए, as it has been pointed out, इसमें तो इन्होंने सपोर्ट किया है कि जो है jurisdiction को बढ़ाना हो, supplemental करना हो तो कर सकती है पार्लियामेंट।
वो रिपील हो गया ना 247 जो
नहीं, आप कौन सा
Repeal
कह
तो
रहे
हो
हैं?
गया, but the judgment is there, सुप्रीम कोर्ट का अपना जजमेंट तो है ना, वो रिपील
Hello, para 37 of Baz Muhammad Kakar. If I can just read this out, Article 247, Clause 7. As now
Page
it's
कौन
been,
सा पढ़ रहे हैं page?
well, this is the Constitution itself. This was prior to its repeal
No,
by the
Azimut Kakar का page कौन सा?
page 967, para 37.
Citation.
This was PLD 2012 Supreme Court, 923, para 37 at 967. This is one example of enlargement of jurisdiction of the Supreme Court in terms of Article 247, Clause 7, which read, my lord, neither the Supreme Court nor a High Court shall exercise any jurisdiction under the Constitution in relation to a tribal area unless Majlis-e-Shura, Parliament by law otherwise provides. And pursuant to this, an act was promulgated in 1973. And this was taken notice of by this honorable court in. My lord, that's one example. The other is, as your lordship mentioned, Article 185 of the Constitution.
185.3 is very
185, 2D and E.
2, 3, Sorry,
These are
D,
express authorizations by the Constitution.
D, yes.
185 to D and also E.
नहीं, ये पेज 970 पे सप्लीमेंटल पावर का भी जिक्र है। पेज 970 पे जो पैराग्राफ है ना, वो आप पढ़िए, वो डिटेल में है।
जी जी,
उसमें ये क्लैरिटी आ जाती है,
Mr.
as it has been pointed out
My
here and
que-
above.
My question is that even for a minute, I mean, I'm just something that if we were to leave 55 for a minute, what is really I mean, it's a question of interpretation. What's really stopping us from interpreting 191 to mean that it actually is actually envisaging a law for practice and procedure? It is the enabling provision. Suppose if we go in that direction, what comes in our way? I mean, that sort of solves a lot of mystery also. It is saying that the Constitution is envisaging that the Constitution could provide for practice and procedure, some law could provide for practice and procedure, and the Supreme Court can its rules provide for procedure. Meaning by, one way of looking at it is, meaning by that the Constitution is saying that, yes, for the purposes of practice and procedure, there could be a law. So 191 could be read as an enabling provision. If that is read as an enabling provision, then it sort of solves.
My lord, with all due respect, in my opinion, it can't be read as an enabling provision. It is a limitation, and the limitation that it imposes on the Supreme Court's power is not limited to practice and procedure.
No, but
Let me just finish. Supposing the can the Supreme Court rules cannot say that in adjudicating our appeals regarding contractual issues, we will not take into account the
So
contract. Act.
my problem is that suppose there were no rules made by the Supreme Court. So how would we look at 191 then? And then there is a law, the word law is mentioned. Suppose it's a total green field, there's nothing in the, so then a law could be there to regulate the practice and procedure. If the Supreme Court decides not to make the rules for a minute,
Well,
then the source could be law itself.
well,
So then to call it limiting would be not.
Well, could it be provincial law also? The law
No,
will
considering
include.
that it relates to, I mean, that's another issue with entry 58, that what does relate to federation mean? So if it relates to federation, perhaps it's a federal law that we're talking about or not? That's another question that I want
My
to
lord,
ask.
the problem,
In entry 58.
what I said, there is a structural limitation on the word law in Article 191. You can't read it. Shoresh Kashmiri's case, PLD 69, Supreme Court 14 said, law is very broad. But here you will not include provincial law. You will, in my humble opinion, you will not include ordinances because ordinances are executive acts. If you allow, well, if I can just finish this. Well, if you allow ordinances and rules, which are law, to be read into law in Article 191, what happens to 175.3? Judiciary has to be separate from the executive. How can you allow the executive to make rules for practice and procedure of the Supreme Court? So the word law in 191 has inbuilt limitations. I concede that it will include Act of Parliament, but in certain limited circumstances. Only when entry 55's conditions are met.
So your
then
answer to the issue is that you would come through 55, you would come up with a law that relating to enhancement, which is explicitly provided, and in that law,
Yes.
you could then ancillary
by
provide
virtue
for
of entry
practice
59.
and procedure.
That's my reading.
That's the only way to
That's
get.
that's the only way you.
But then those provisions would relate to the enlargement part,
Yes.
not anything more than that.
Not anything, and that's why I say it's a very restricted power. My lord, sorry.
In terms of you raised a very interesting way to look at this thing, but I think if we look at law as conferring an enabling jurisdiction, I think one issue with 191 is that we have on the same thing, namely the practice and procedure of the court, we have two law-making powers. One is the Supreme Court. It's a direct grant by the Constitution. And if law is read in an enabling sense, then Parliament also. So this creates a situation where on the same subject matter, if I may use that term, ordinarily the problem arises where on the same subject matter, the division in terms of law-making ability is between federation and the provinces, right? So to take a very simple example, entry 49 of the taxes on income other than agricultural income, right? So the subject matter is tax on income, and the constitution splits it into two. Agricultural income goes to the provinces, this goes to the, and we have whole issues of trespass and this, that, and you know all of that. Here, the interesting thing is that on the same subject matter, practice and procedure, you have the constitution is giving a grant to the Supreme Court itself. If law is read as an enabling power in Article 191, then the same power is conferred on a separate branch, the legislative branch. So, in terms of the principle of separation of powers, how do we resolve? How would we resolve a conflict if law over there is to be read as an enabling power? In terms of legislative competence, the division between federation and provinces, we know all of that. But here, how would we draw the distinction? How would we resolve a conflict? So maybe, because speaking for myself, I'm not too satisfied with with the way you are identifying it with entry number 55. Seems to me that a more natural on your reading would be entry 58. But that would mean that it is not an enabling provision. It doesn't really, it allows them to restrict. Otherwise, the conflict between two separate branches, making something that is law on the same subject matter, how would that be resolved?
My lord, I will address that.
Yeah, I think that's an excellent question. You want to mull it over. We will reconvene after lunch or prayers. ठीक है? तो आप आधे घंटे में वापस आ जाते हैं.
आधे घंटे में ठीक है.
ठीक है, you can mull it over the question before you start. We don't want to cut you short and you start something it doesn't finish.
ठीक है.
ठीक है.
ठीक है, I'm grateful.
As in practice,